My lord, grant me leave to mention, my lord, extension of interim order, my lord.
Are you mentioning upon notice?
I shall-
Are you mentioning upon notice?
I shall serve notice.
No, no. Please mention.
Actually, with
My Brickfield has been closed, and my lord, I was not party. If an order was passed against the statement, my lord, my Brickfield has been closed.
Give the number.
Yes.
with your lordship's
Similar
leave,
appear in the Thursday. I have Mr. Congress, but
your lordship, your lordship may recall.
Are you mentioning upon notice?
yes, I have.
Your
Actually, with no-
lordship may recall.
My lord, with notice to other side.
How about that?
Your lordship.
Thursday, I can do
Ah.
it Thursday.
My lord, with
Lordship may
notice to
recall.
other side, my lord.
I've supplied
Mentioning one urgent Group 7 motion, my lord. Group 7 urgency is this, my lord. The petitioner lease has been terminated on the ground of overloading, single overloading, whereas the policy says 3 overloading is minimum required. Now, my lord, that has been terminated, my lord. Now, in furtherance of that, my lord, they have initiated one tender which is going to open on 11th of December. Lordship, I have filed this writ application, my lord. I have served other side. It will appear in due course, my lord.
Your lordship, kindly, your lordship recall, my lord. What was asked for? I have supplied. I've
Yes, sir.
written,
It's
I've
upon
given the
notice.
number. Date.
Upon notice?
Yeah, notice at least 11 occasion I've given.
No, no. This mentioning is upon notice.
Yes, I've already mentioned. I've told him that this is appear. This will appear.
Mentioning the notice is
Hmm.
mentioning the upon notice.
My lord, may I permit it to mention?
My
lord,
may I
may-
be permitted to
on-
mention it is an
Several
urgent-
occasions mentioned, ma'am.
It's an urgent listed motion. The petitioner is not being allowed to apply the Toto Rishka because there is some license fee at the state government has. Are you mentioning upon notice? Yes, I have mentioned. Give the name.
My lord, may I permit
Typographical error of the final order sheet.
Correction to be mentioned. Correction.
My lord, may I permit it to mention, my lord, this is for hearing matter upgradations. The matter is that the petitioner is asking
Are
for.
you mentioning upon notice?
Yes, my lord.
Affidavits are complete.
Yes, my
Give the
lord.
number.
My lord, this is an extension of interim order, my lord, upon notice, my lord.
My lord, may I permit to contempt application?
Fresh contempt.
Yes,
Lordship, may I permit to mention contempt application?
Friday, Millard, an order was passed for service, Millard, in a contempt petition. But by the time I went to service, Millard, new incumbent has came in. Millard, to be mentioned only for correction. Millard, Friday I mentioned.
Are you
the
mentioning
matter.
upon notice?
Millard, how can I give notice, Millard? New admission matter, admission done, service affected the, Millard,
It's the sole alleged contempt. Done.
yes. Millard, that's why, Millard,
Give the
Friday I mentioned.
Give the number.
Lordship, may I permit to
Kaলকে
mention
তুমি mention
contempt application?
I কালকে দিন বলেছিলেন।
To be mentioned. একটা note রাখো।
731, my lord, what happened, my lord? In this matter, my lord, petitions are completed.
Are you mentioning upon notice? Please mention upon notice.
Lordship, may I permit to mention contempt application?
Fresh contempt.
My lord, contempt application also, my lord.
New
Yes.
contempt.
Yes, my lord.
My lord, may I be permitted to mention one matter? My lord, this is a group 9 matter inadvertently filed in group 1 matter, my lord. My lord, Justice Vivek Chaudhary has already heard the matter in to be mentioned and has released the matter, but it has again came in the list, my lord.
Are you mentioning upon notice?
My lord.
Order for release.
My lord, may I permit to mention, my lord? May I permit to mention, my lord?
Yes.
My lord's order on October 2023, affidavit in opposition filed, but nothing.
You are appearing for the petitioner.
My lord,
Opposition is not filed.
not my lord.
Who is appearing for the state?
My lord, already I served the notice, my lord.
Are you mentioning upon notice?
Yes, my lord.
May I have your lordships kindly, to mention for inclusion, this matter was running in your lordships list on Friday.
was listed as item 284. Matlab, today we see the matter has gone out of the list. But I am only praying for
Today
it.
only monthly list matters are appearing,
Yes,
sir.
Matlab, it was
So why don't you wait for tomorrow? It will appear automatically.
very well, Matlab.
Supplementary list matters are not being included in the monthly list
Very well.
to avoid confusion.
And if it is not the case, then we'll
Yes,
come back
yes.
to it.
I hope it will appear
Very
automatically.
well. I'm grateful.
Well, may I permit to mention, my lord, inclusion, my lord. Upon notice, my lord, I am mentioned. It is not in the list, my
Now, is it the supplementary list?
lord. No, my lord. Not in the list.
You're mentioning upon notice?
Yes, my lord. And one, my lord, updation, item number 432, my lord. This is, my lord, related to, my lord, compensation of land.
Upon notice?
Upon notice.
Your Lordship, I'm mentioning a matter for inclusion of inclusion in the daily list.
What is your urgency?
Your Lordship, that I am a petitioner. I am a e-vehicle manufacturing company, and I cannot obtain registration from the state government as well as the regional transport officers, and I cannot run my vehicles. And it hasn't all been.
Mentioning upon notice?
Yes, sir, my lord.
Lordship, may I be allowed to mention one matter for inclusion in the list? I'm mentioning upon notice, Lordship. This matter was heard before your Lordship. My tower, mobile tower network, the electricity from that tower has been disconnected. And till date, it has been disconnected. Directions of the affidavit were given by your Lordship, but till date, no affidavit has
City
been filed.
disconnection, how does this court have determination?
Lordship, this court has determination. This was heard before your Lordship on August 23rd, 2023, Lordship.
See the number.
May I be permitted to mention for upgradation these three matters, my lord. Analogous matter is the only consideration matter. My lord, since September, my lord, it is continuing in the list. Gradually, my lord, it goes down to your
It's
lordship.
appearing in the daily list, in the supplementary list?
No, my lord. Only monthly.
It's appearing in the monthly list.
Monthly list. My lord, from
You're
September.
mentioning upon notice?
My lord, it is the first time I do not know who is appearing, and therefore, my lord, I have to.
Please find out, please mention upon notice.
May I have your lordship's kind leave to, my lord, mention one, my lord, writ petition is extremely urgent, my lord, for upgradation is appearing in your lordship's, my lord, supplementary list on the last date, my lord. It's appeared as item number 497, in which, my lord, one lease deed was, my lord, already
Wait
expired, my
till
lord.
tomorrow. Today only monthly list matters have been printed.
My lord.
Supplementary list
My lord.
matters are not included in the monthly.
Tomorrow
list.
I will come back.
It may automatically appear. Please check the list and then mention.
My lord, it's appearing in your lordship's list, my lord.
So it will
My
again
lord, for upgradation, I'm mentioning, my lord.
come back
Yes, sir.
tomorrow. Let us
My
see
lord, my,
the serial.
my
serial
lord,
number, then
my, I'm grateful.
Lordship, praying for mentioning rectification for order. I serve the copy other side, sir.
You're mentioning upon notice?
Yes, Lordship.
Correction. To be mentioned, correction.
My lord, I mentioning for upgradation. Urgency is private respondent had forcefully occupied the
You're mentioning
PW.
upon notice, madam?
No, ma'am.
You have to mention upon notice.
Notice there, ma'am.
Na dile debe na, rekhe dikhele. Please call the days list, please.
Jalpaiguri Circuit Bench matter, item 1.
On for the petition.
Lordship, this matter relating to the
Where is your service?
word. They have appeared, Lordship, just now. One day.
Who is appearing?
Miss Motorima Shodkar, an advocate.
Not recorded.
She was there. Lordship, this matter.
What is the contempt application? Didi, contempt application? Oh, it is a rich petition. Oh, देखिए ये लिखा है.
बोलो की देता
Yeah, Lordship.
Who is the contempt now?
Lord, notice service होगा
The block development officer. You are.
Yes, my lord, notice was served upon my lord.
Yes.
Lordship.
Is it complied?
No, my lord, what happened, my lord? There was, my lord, your lordship had directed, my lord, consideration of the representation. Now, my lord, above from consideration, my lord, part payment was already released.
Lordship, may I, Lordship?
Part payment was already released.
That is part compliance.
My lord's order was only consideration. My lord, we have, my lord, from our end tried to release, my lord,
Affidavit of compliance.
my lord, there was no such direction, my lord.
So will you come back with your compliance report on the
Definitely,
next date on an
definitely,
evidence? Let
definitely,
it come back.
definitely.
When it will be.
Yes, is it complied with, madam? Are you aware?
Lordship, this matter is related to 2013 and till date only out of 13 lakh 50,000, 3 lakh 40,000 disbursed
The
from there.
representation considered, that was the direction.
Lord, we had
The presentation considered?
my lord, before that, my lord, we have, my lord, complied with, my lord, it's
So
to the
please come
benefit.
back, let him come back with
It's
an
to the
affidavit
benefit of the
compliance.
petitioner itself. Your
Please
lordship,
come back with
I
an
will,
affidavit. Contempt, eh?
kindly gives me 3
Affidavit
weeks
of
time, my lord.
service.
Such a specific direction. is
Paragraph,
required.
learned counsel for the alleged contemner submits that the order under contempt has been complied with. Stop, he seeks to
State can
file affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on
kindly gives me 3 weeks time.
18 December.
18.
Come back before the vacation.
Very well, very well. 18 December. Affidavit from court. TDS.
Next.
In December.
Regular bench matter. Item 1.
এটা একটু ঠিক করে দেন।
Petition.
I am for the petition.
File করে দেন। এই করে দেবেন। ও judgment.
The writ petition is allowed. I'll read out the objective part. It has been held by the Honorable Supreme Court in the authority in Comptroller and Auditor General of India that the High Courts in India exercising their jurisdiction under Article 226 have the power to issue a writ in the nature of mandamus or to pass orders and give necessary directions where the government or a public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion malafide or on irrelevant considerations, or by ignoring the relevant considerations and materials, or in such a manner as to frustrate the object of conferring such discretion, or the policy for implementing which such discretion has been conferred. In the present case, since the concerned authority has exercised discretion on irrelevant considerations by ignoring the relevant considerations and materials, the order impugned dated 10th April 2023 is required to be set aside. It is held that the petitioner is entitled to extension of the lease for the lost period from 25th March 2021 to 22nd February 2022, during which he was unable to continue with mining operation. The writ petition is accordingly allowed. The Assistant Secretary, Department of Industry, Commerce and Enterprises, being the second respondent herein, is directed to allow the representation submitted by the petitioner dated 18th August 2022 and grant extension of the lease for the period during which the petitioner was unable to continue mining operation. The period is mentioned. The entire exercise should be completed within 6 weeks from the date of communication of this judgment.
Gets lordship. Problem.
Item 2.
My lord, this matter has appeared at my instance. There was a correction to be carried out in your lordship's order. My lord. No, just the date needs to be rectified. My lord.
Did you
My-
mention upon notice to the other side?
My lord, my learned friend had mentioned it on Friday and it had been directed to appear as to be mentioned today.
The others are not appearing.
No, my lord, it's a correction of a date only, my lord. If the last line instead of 15th, it should be 16th of January.
Oh, I had said 16th.
That's right.
The matter has come up under the heading to be mentioned at the instance of the private respondents. 8 to 13.
8 to 13.
Being respondent numbers 8 to 13. Paragraph, inadvertent error has crept into the order passed on 28th November 2023. Paragraph, in the last line of the order, in the last January 15, 2024, be read as January 16, 2024. Paragraph, the department is directed to incorporate necessary correction in the order accordingly. This order be treated as part of the order passed on 28th November 2023. Urgent certified website copy.
Great, sir.
Item 3.
My lord, I am for the petition.
Yes, what is the correction required?
My lord, your lordship, dispose of this application directly to the mentioned authority, that is the divisional commissioner, who is respondent number 2 in the writ petition. My lord, instead of respondent number 2, it has been recorded as respondent number 3.
Mr. Dey is appearing in this one.
Yes.
The district magistrate will not deal with this.
My lord,
3 is the district magistrate.
3 is the district magistrate whose order is under challenge before the divisional commissioner, which is respondent number 2. Appeal is pending before the divisional commission.
It's pending before the second respondent. The matter has come up at the instance of the petitioners, come up under the heading to be mentioned under at the instance of the petitioners. Paragraph, inadvertent error has crept into the order passed on September 6, 2023. Paragraph, in the third paragraph of the second page of the order, comma, the third respondent be read as the second respondent. Department is directed to incorporate. This order be treated as part. Yes, next.
Item 4.
But my applications are pending in the last occasion. Last was pleased to direct Millet to file opposition to that extent by the Millet, the other side. I just
35 delay, lordship, in the
36 days.
36 days.
35 or 36 days. For changing of advocates. Very well. Millet, I just take your lordship to the Millet fact of the cases, Millet.
You are the applicant petition.
Applicant Millet, I am seeking for the recalling of an order of your lordship, Millet, which and Millet, we are facing the contempt. I have Millet categorically stated, Millet, why this is Millet required. If your lordship kindly takes trouble to see Millet
before going to the
wait a minute. My application. It's my application.
You
sir.
may be
It
your
is my
application. Lordship, there is a section 5 application, condemnation of delay. 36. Let this delay be recovered. Delay be condoned. Otherwise, lordship.
Very well.
Yes, delay, let it be condoned.
Yes.
Come
No,
back.
lordship, delay, I have objection.
You have
Strong objection against the delay.
Do
Obvious.
you want to come back with an affidavit in opposition?
Your lordship direct I file. But lordship, the
I
delay.
will not direct. Do you intend to file an
Yes, yes, obviously.
covering
Delay,
both?
absolutely abnormal delay. Without any. Even till the delay is condoned, lordship, we have no right.
Millet, I will also show Millet to that extent.
Certainly.
The person concerned who has obtained this order has not come with the clean hands. I will show Millet.
That will be appeal.
Absolutely, Millet.
It's a ground for appeal.
No, it is not.
Yes,
It
ground
is
for
not.
appeal.
If you have not come with clean hands, that can be considered.
Yes,
illegal.
yes. I will show Millet.
I call him.
I will show Millet.
Provision of
There's
recall.
a provision for review.
Yes, yes.
This is not a review application.
This is a modification and recalling application.
Where is
Millet.
the law? Where is the law?
There is no provision for recalling as such in the code.
No.
It-
Where
there
is the
a
law?
provision for review.
Review. That's right. Miss.
And this is not the order 47
Mr.
say.
Mukherjee, you're technical. You're being technical.
It's a very
This is
technical
law.
one.
Must be a person suffering since long time. This is the delivery of a deed, registered deed that has not been
Oh,
delivered.
very well. If my learned friend is open up to case, my lord, I am ready to argue the matter.
Let him come back with his affidavit in opposition.
My lord.
Against both, one and can 2.
Let the delay be condoned, Lord. Because delay subject to
After
my
the delay is condoned, you'll again want to come back with an affidavit in the other matter. So why don't you file affidavits in both the matters together? It will be dealt with together. Yes, that will save time.
My lord.
Learned counsel for the petitioner. You are the petitioner in the writ petition. Learned counsel for the petitioner in the writ petition seeks to use affidavits in opposition in Can 1 of 2023 as well as Can 2 of 2023. Paragraph affidavits in opposition we file within 2 weeks. Mr. Mukherjee, within 2 weeks? Within 2 weeks? Within 2 weeks from date. Paragraph affidavit in reply, comma, if any, comma, we file within a week thereafter.
My lord.
So that takes us to the vacation.
My lord. After the
Paragraph-
reopening, they are coming up.
Let the matter appear under the same heading on 10th January.
As you lordship.
Lord, so I filed the no objection of the earlier step. Already filed. Already have.
Let the deed in question, which has not been executed by my learned friend. I will come. I will show me.
Item 5.
But I appear for the alleged contempt now, my lord.
Apply.
My lord, we have assailed this order before the Honorable Division, but the order of stay has been passed in this matter. And in the order to the auditor.
So it is that matter where a
That matter,
proposal was
my
there,
lord.
right?
Can 1, my lord, in the third page, first section 5 application was allowed. Thereafter, in Can 2 is the stay application. If your lordship kindly sees page number 4, it's an elaborate order.
Status quo with regard to the property.
Your lordship kindly sees page number 4.
Yes.
The second paragraph. In such circumstances, it would be appropriate to grant stay of the impugned order dated March 9, 2022
Very
till
good.
December.
So let it go out of list for the time. Your opinion?
I am for the petition.
It is submitted on behalf of the alleged contender that the order under contempt has been carried in appeal. And the Honorable Division Bench has been pleased to grant stay of the order dated March 9, 2022 till December 31, 2023 or until further orders, comma, whichever is earlier. Paragraph in view of the above, let the matter go out of list.
I'm grateful.
Item 6.
My lord, in this matter, I beg to appear on behalf of the petitioners, my lord. As per your lordship directions, the contender issued a notice for hearing, my lord.
Order has been complied with?
Not, my lord. I am coming into this, my lord. Kindly consider me. My lord, this is the notice of hearing, my lord. And my lord, kindly excuse me, I have one copy of the region order passed by the contender, my lord. Kindly see the paragraph 3 only, my lord.
My lord, I have complied the order. I annex all the.
Kindly allow.
The order is here.
Kindly allow me to submit, my lord.
Submit করবে তো আমার এটা তো আমার
He is the alleged contender. He has to.
Yes, my lord. Kindly allow me to 2 minutes for submit, my lord. I just show the order, my lord.
The order is annexed.
Region order, my lord.
27th September order. Didi, apna haterta dekhun. 27th September order. Same order is here.
Yes, yes, my lord. My lord, kindly come to the paragraph 3 of their orders, my lord. My lord, kindly come to the paragraph 3 of their orders, my lord.
Yes, yes.
My lord, kindly, may I please, my lord. As per the report of the block land and rail reforms officer, Chandrakona 2 blocks, white memo number Sergeant Charge, date Sergeant Charge, it appears that disputed plot number 677, 678, 679 and 680, total area of 0.682 acres each Rayati land and recorded in the name of writ petitioner, which is between the alignment of this said road, my lord. My lord, it is admitted that my land, petitioner's land within the road, my lord. It is their order.
Alignment of the road, my lord.
Yes,
That
my
is
lord.
not
Kindly allow me. Kindly allow me, my lord.
বলো ইংরেজিটা।
After knowing the fact, executing the authority, PWD roads director did not made any construction on the said plot and area, my lord.
Yes.
My lord, kindly consider. This is the.
You are submitting on merits of the.
No, my lord. I am not.
Question,
Yes,
right?
this order, my lord.
You are on merits of the order. That is a separate cause of action. I'm sorry, sir.
No, my lord. Kindly consider, your lordship.
You cannot consider the
My lord,
merits of the
kindly
order.
allow me for a moment, my lord. I am a petitioner. I filed writ petition. Then my lord, this is the 5th time in contempt proceeding I appear before your lordship. My lord, kindly allow me for a moment, my lord.
Time unnecessarily, sir.
My lord, allow me 2 minutes just, my lord. My lord, your lordship please to direct in open court when the assistant engineer of PWD present in the court in personal appearance to measure in before of us, to measure the length. They did not, my lord. We do not know how they measure, and it is admitted that, my lord, and kindly consider, my lord, they already used our length. This is the photograph. This is our contention, our repetition, my lord, and install the calvert, big calvert, my lord. This is the photograph, my lord. My lord, they are already constructed on the our length.
So you are not happy with the decision taken by the authority, right?
Yes, my lord.
So
My lord, this is the calvert they install already.
happy you have to challenge the. It's an appellate order, Mr. Dev. It's an appellate order. The decision is it's appealable.
That decision?
Assistant engineer.
Just normal.
Even then, you have to challenge the order before.
My lord, kindly consider. I filed the writ petition. Your lordship direct to not to construct. That order they violated. Thereafter they come.
Direction not to construct. Please show me.
Kindly see, my lord, my contempt application.
Where is the direction of this court not to construct?
My lord. I show you. Kindly allow me. The certified copy of the order, my lord. Page 32, my lord, my contempt application.
Yes. Yes. Pending disposal of the representation.
Yes, my lord.
So representation has been disposed of.
Disposed of now, my lord.
Yes.
My lord. And in the meantime, they constructed. upon my land, my lord. My lord, I saw the photographs, my lord. Kindly consider. We are the litigant, my lord. We the
Photographs, according to the map, can it be made out that it is your land?
yes, my lord.
Where, please show me where.
My
is
lord,
the-
your
where is the
lordship
measurement?
kindly consider when the engineer of the PWD consider and take a hearing without taking any measurement. He just kindly see the order of their regent order.
This is a contempt application. This is not a writ petition.
My lord, my lord. My lord, they
Direction
passed.
was to consider your representation. That has been done. You are not happy with the consideration. So you have to challenge the order before the appropriate forum. How can you challenge an order under contempt in a contempt application?
My
I
lord,
cannot go into merits of the application.
my lord, they constructed their.
So please take necessary steps. That cannot be. You are aware, sir. You contempt application. The scope is very limited.
My lord, kindly consider. My lord,
Consider
consider they are the state authority. PWD is not a private respondent. They are the state authority. Without any notice, they take the land and constructed it. Then pass the region order. We will not take your land.
Stated upon on affidavit that they have only made an alignment through the border of your land. They have not taken your land. That is on affidavit.
My lord, kindly see the photograph, my lord. My lord, kindly on my cost, appoint a special officer or receiver, any of the.
Please show me the provision, sir. Please show me the provision.
Then, my lord,
I'll definitely do it. I told you in the
my lord, then my lord, kindly consider petitioners are remediless. Again, they filed the writ petition.
Challenge the order if you are not happy.
Again, they have filed the writ petition. Again, they filed a contempt application. My lord, kindly consider their regent order, my lord.
Please show me one provision that I can deal with the merits in a contempt application. I will definitely do it.
My lord, at least they measure the land. They take or not take my.
Please show me a provision where they can measure the land in a contempt application. Please do not make these submissions beyond the law, sir. Please do not do this. I understand your plight, but
My lord, they did not comply with the order. Within meantime, we come before the court, file an contempt application, my lord. They just passed a regent order
that was the direction
without considering anything, my lord.
of compliance. Paragraph, it appears that the order under contempt has been substantially complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of. Paragraph, there shall however be no address to costs as in certified website copy.
My lord, kindly give me liberty to challenge this order. Just.
The law gives you the liberty. This court doesn't need to give you liberty. It's
Well,
a
again-
cause of action altogether.
I understand.
Next matter.
7.
I have for this. On the last occasion,
Yes.
the PWD authority, they took time, my lord, to comply with your lordship's order. And subsequently, they issued a notice upon the private respondents for vacating the concerned land of PWD. So thereafter, I do not know, my learned friend can say, my lord, what steps they have taken, my lord, to comply with
Yes,
your
who
order.
is appearing for this? Your
My lord, lordship kindly sees. Now, I am appearing in this matter on behalf of the alleged contender number. My lord, 2. I am for 1.
Yes.
Now, my lord, kindly sees your lordship's order. My lord, subject to correction, prima facie, your lordship's order dated 21st of September 2023. That needs to be corrected, and that's why I have mentioned this matter. Now, my lord, lordship kindly sees report submitted on behalf of the alleged contender is taken on record. Learned counsel for the alleged contender submits that, my lord, this is the steps. Lordship has seen the order.
Yes.
21st of September 2023. Now, my lord, the difficulty is this. Again, lordship kindly not take amiss of me. It is very difficult to impress upon my client that actually I appeared before your lordship. Lordship kindly sees Mr. Prashanto Vishwal for the applicant petitioner, Uttam Kumar Bhattacharya for the alleged contender number 1. So my learned friend is for alleged contender number 1. Now, my lord, my name or the name of my junior, we appeared, there is no dispute, but that is not reflecting. So lordship,
Corrected. That's
my
not
lord,
the issue. Yes.
my lord, kindly, and
Who's the
in the
complaint?
meantime, now my lord, in the meantime, lordship, the alleged contender number 2, my lord, he has handed over charge, and my lord, another person, my lord, Shondip Chatterjee, he took charge of the executive engineer. Now, my lord, kindly appreciate this in compliance of your lordship's order, my lord. The erstwhile executive engineer, that the present contender number 2, he has referred the matter before the concerned authorities under section 10(1) of the West Bengal Highways Act. So, my lord, that particular authority is to take steps in accordance with law. The private respondent, they have a remedy under the statute. So this is the stage of the matter. So if your lordship kindly call for a fresh compliance report, my client.
On the earlier date, where is it? It was supposed to come today. Where is the compliance report?
My lord, kindly gives me a week's time or 2 weeks time. So, but my lord, the name of the current executive engineer then has to be incorporated.
I'll request you to include his name.
Yes, my lord.
And since you are appearing for them, notice need not be served, fresh notice, or let there be a service because it's a
Yes,
contest.
my lord. Yes, my lord.
There will be a person.
Yes, my lord. Subject to correction. So present status report, along with present status report, my lord, I will come with a affidavit of compliance.
Instructions to conclude the proceedings.
My lord.
Section 10 cannot go on for time immemorial, isn't it?
My lord, subject to correction, that is not within the domain of the executive engineer. That is within the domain of the subdivisional officer. He is not a party to the writ petition, neither the contempt application. My lord, subject to correction.
This is a section 10 subdivisional officer has nothing to do. The assistant engineer will do. Because section 10 has been issued upon demarcation of the land.
And by whom your authority will get it executed, that is entirely upon you.
Lordship, let them incorporate the name of the present executive engineer. My lord, I will file compliance affidavit.
To the executive engineer, so let him take necessary steps.
Yes.
Yes.
And government land, I have not referred the order to the government land, to the government authority for their compliance.
It's PWD land actually.
PWD land. They passed the order ultimately, and after that they transmitted it before PWD.
On prayer of the, now it is submitted on inadvertent error has crept into the order passed on 21st September 2023. Paragraph in the cause title of the said order. The names of, please give the names.
My lord.
Mr. So-and-so, be recorded as learned counsel for the alleged contender number 2. Paragraph, learned counsel for the alleged contender number 2 submits that the alleged contender Ardhendu Shekhar Mondol has been transferred. And who is the present incumbent?
My lord, kindly. My lord, Mr. Shondip Chatterjee. Shondip Chatterjee.
Shondip Chatterjee is presently posted as the executive engineer, PWD, Tomluk Division. Paragraph, in view of the above, liberty is granted, in view of the above, the name of Mr. So-and-so be added as alleged contender number 3 in the contempt application.
My lord.
Paragraph, the petitioner applicant is directed to serve copy of the contempt application along with annexure thereto upon the alleged contender number 3 and file affidavit of service on the adjourned date. Paragraph, London Council for alleged contender number 2 seeks accommodation to comply with the order under contempt.
No, my lord, that will be an affidavit subject to correction on behalf of alleged contender number 3 now. So, my lord, after service of notice, my lord, I will come back with a affidavit of compliance.
Paragraph, let the matter appear under the same heading on. Will you come back after vacation?
Yes, my lord. But before vacation, my lord, my lord.
By 3 days? Very good.
By 3 days it will be effective.
19th December.
19th December, my lord.
And in course of today, my lord, we will, with leave of your lordship, my lord, we will.
Oh, that's 19th December, Monday.
Next.
Monday.
19th December.
Monday.
Item 8.
Please serve and come back. Service at direction. After vacation. 4th January. 4th January.
9.
Lord, the order has been complied with, my lord, on 29th of September 23. My lord, immediately thereafter on next day, they, my lord, alleged, they lodged an FIR with us
saying that the accused persons were again intimidating them and stealing away their fish. On that, on the very day, another FIR has been registered. No service has been received by us, but my clients instruct me that with regard to that complaint, they have filed another writ petition for police inaction, etc. But as far as your lordship's order is concerned, altogether separate aspect, this time is being sought, perhaps to agitate that fresh cause of action. On 29th September, they have given written declaration that they are satisfied with the compliance that.
Have you served?
First they seek time, then they filing supplementary affidavit.
Why
No
are you
copy to
seeking
me.
time? Why are you seeking time?
This is there, in writing they say that we have complied with the order. If your logic kindly takes a look at this document, and if time is required, they may get the adjournment they seek. For the entire exercise starting from 5 a.m. in the morning, we have given a CD drive also, not the drive, I'm sorry, the compact disc, page 15,
When was this done?
29th of September.
So this
From
is after the earlier order.
After the earlier order. In the when it appeared on the last occasion, I made the submission that it could not be demarcated. The demarcation took place and immediately we put them back in possession. And it takes page 15. It is I'm showing this because it is their letter itself. 15 and 16. Copy to them supplementary.
What was the order?
Page 23 of the contempt application.
Your pisciculture.
No, my lord.
On 29th, we have put them in possession.
One day. Yes.
Yes, on 29th. Then, on 30th, they say they have lodged another FIR. If your lordship kindly takes, the photographs, of that day is there. Kindly takes page 24. This is the fresh FIR that they have registered on 1st of October, after 2 days.
So the order was not only for a day.
Continue, my lord. On next day, on
One day they have been able to do it. What about the other days?
other days, my lord, on the allegation made, my lord, your petitioner made a complaint, my lord. The anti-social who were disturbed the study, my lord, they were lost complaint and made a FIR on behalf of us, my lord. They were.
Two FIRs, kindly sees page 24 as well as page 28. For these,
this order is not for only one day, my lord.
fresh acts of criminal action, we have taken steps. We have registered the complaint, As per our instructions, they are carrying out the pisciculture, and whatever disturbance they are facing on the basis of their complaint, we are taking steps.
Why don't you come back with an affidavit of
Well,
compliance?
petitioner
annexing
they
this
were
document?
lost a complaint, my lord.
Let the state come back with an affidavit of compliance. Let me see.
The supplementary affidavit may be given to.
You've served a copy?
No, not yet.
You take this one.
Junior Standing
Supplementary
Council.
affidavit submitted on behalf of the applicant petitioner is taken on record.
9830.
Paragraph learned counsel for the alleged contemner submits that the contemners submits that the order under contempt has been complied with. Paragraph learned counsel seeks to file affidavit of compliance on the adjourned date, annexing relevant documents. Paragraph, let the matter appear under the same heading on. Will you come back after vacation?
Next week, ma'am.
21st. 21st December. Interference. You can take back your order.
Item 10.
Person, please serve and come back. The applicant petitioners are directed to serve copy of the contempt application along with annexure thereto upon the alleged contemptor and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 15th January
My lord.
2024.
Item 11.
Well, I'm appearing for the petitions. This one first time.
Person, please serve and come back. Same order, 15th January,
15 January.
3 weeks more. Serve and come. It's a new content.
First week of the vacation, well,
Very well, 9th January.
grateful, my great.
Vashu, 9th January. Service and direction, same one.
Item 12.
12, my lord, I am for the petition. In the previous occasion, a direction was passed upon the state to file affidavits. They have not served till
I've
date.
been told Mr. Tarakorni is appearing for the state.
Yes.
And he was not well, so he was paying for some time to file the opposition.
My lord,
What are all these applications about?
my lord, there are 5 applications actually, my lord. My lord, restoration and recalling, setting aside of abatement and substitution, my lord. And delay, there are 2 delay applications. These makes it
So
the
you
5
want to
cap.
come, yes, they.
My lord,
file it.
kindly expedite the process. My lord, may be pleased to recollect that on the previous occasion, Mr. Karan for the state, my lord, raised vehement objection and sought for affidavits, my lord. So, my lord, kindly expedites the process. Because, my lord, the land that was allotted to me in all the merit of the writ petition is the land that was allotted to me. That allotment has been cancelled. That is the merit of the writ.
Because you did not take steps for considerable period.
Yes, my lord. But there were 2 successive deaths in the family of the male members of the family. That is the reason, ma'am.
You've annexed those documents?
Yes, ma'am. Within 6 months, 2 brothers died.
Learned counsel for the respondents seeks extension of time to use the affidavit in opposition as sought. Paragraph, let the matter appear under the same heading on come back after vacation.
Ma'am.
16th January.
I'll kindly make it the last chance.
Please, if this is the first chance that they're asking for. But please exchange your affidavits in the meantime.
I'll convey them.
January.
Lordship, I am for the respondent number 12 to 20 of this writ petition, Lordship. Lordship, the affidavit of service kindly be.
This is your application.
Yes, Your Lordship. Lordship, this is an recalling application of your order dated 16/8/2023, Lordship. Lordship, I have only the notice under section 10 has been served upon me. Though I have only 2 submission, Lordship, that I have been instructed.
Oh, yes, you're
Your lordship, but no copy was served upon us.
Here's the affidavit of service. It's served. The affidavit shows service. The affidavit shows service. So please contact your client. I'll grant you time, some time. Come back.
Lordship, only 2 submissions, Lordship. I'm not going to go to the merits of the matter, Lordship. I've just been instructed by my client that they have acquired their respective ownership with their deed of sale, Lordship. If that can be submitted, and Lordship, learned advocate Mr. Shukanta Das was appearing in this instant matter on the 16th of August. Lordship, he also gave his appearance, but Lordship, unfortunately, the appearance has not been recorded in the order, Lordship. It can be recorded.
He was appearing on the earlier occasion.
I am not.
Lordship,
Please come back on the next date. Since I'm not taking up the matter today, I'll consider. Because Mr. Debra was appearing.
No, Lordship, he has given his respective appearance, but it
You're
was
for the
not.
state.
Yeah, no, I'm for the respondent number 1220 of this petition, Lordship.
None appears for the private respondents despite service. That is the order on 16th August. So how do you think that he
Lordship,
was appearing?
Lordship, yeah, it can be seen a live stream, Lordship. Lordship, he was appearing. He gave his respective sleep, Lordship, but it unfortunately not been recorded, Lordship.
The order in open court.
Lordship.
Then Why didn't you raise objection that this cannot be
Lordship,
helped?
that it has been mentioned.
Cannot be helped. No, I'm sorry, sir.
Lordship, if the submission, only the submission that the respondent has acquired the ownership over the land via deed of- that
That is on merits.
that on merit, only that can be submission, that can be.
Inclusion of name cannot be done at this stage because it's recorded that the private respondents were not
Lordship,
represented.
if it can, if as your Lordship deems fit, Lordship.
Affidavit of service. It can 1 of 2023 তে order হবে। ये dispose of হয়ে গেছে। Can 1 of 2023 affidavit of service. Paragraph on prayer of the opposite parties / petitioners. Comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17 January 2024.
Lordship, for item number 14, I am for the petitioner.
Yes. Respondents?
Not happy for the state.
Lordship, may I proceed?
Only state respondents?
Yes.
Your Lordship, one Gaurango Chandra Seal, Your Lordship, has applied for a plot of land in Kalyani. Your Lordship, plot was allotted, Your Lordship, and one lease agreement was entered into with him. Your Lordship, unfortunately, he could not continue with the same.
Was executed.
Lease agreement was done, Your Lordship, but unfortunately he could not continue. For that, Your Lordship, during his lifetime, he executed one will in favor of the petitioner and petitioner will. And after death of the original lessee, Your Lordship, the petitioner applied for the same before the Honorable High Court for the grant of probate, and Your Lordship, it has been granted. Your Lordship, after that, the petitioner made one representation, Your Lordship, with the will, probate, and other relevant documents for consideration, Your Lordship. But after the expiry of 1 year, Your Lordship, it has been replied that the plot has already been terminated, Your Lordship. Now, Your Lordship, my only submission is that it is very mandatory, Your Lordship, to the best of my knowledge, that for termination of a lease, for allotment of a plot, Your Lordship, termination, so-cause notice is, Your Lordship, very much mandatory. But in my case, Your Lordship, so-cause notice, to the best of my knowledge, has not been served. Neither to the original lessee, neither to us, Your Lordship. For that, Your Lordship, I have prayed for consideration of my application, Your Lordship, if it can be considered. And Your Lordship, one more submission. In the similarly placed situation,
Which application?
I have made the representation. And Your Lordship, my submission, humble submission is that, Your Lordship, in the similarly placed situation, this Honorable Court, Your Lordship, was pleased to grant the same, Your Lordship. The Honorable Court has granted, Your Lordship, for consideration of the same, and the estate manager has considered the application. Your Lordship, in the paragraph number 10, Your Lordship, has specifically mentioned this, Your Lordship. Kindly comes, Your Lordship. Paragraph 10 of my application, Your Lordship. I have also annexed the order, Your Lordship. Paragraph 10. So I have just came before Your Lordship for consideration of my representation, if it can be considered, Your Lordship.
Let us hear the response.
Lordship.
Yes. Well, if your Lordship kindly takes page 30.
Yes.
Well, the lease, if your Lordship kindly sees, was terminated in 1972. And Malad, thereafter, Malad, he was given the plot. The condition was that he has to build a residential house thereon within 5 years. And Malad, he did nothing. Therefore, Malad, it was terminated and the money was forfeited in 1972. Now, thereafter, Malad, he made a will when he really did not have any right over the property. And Malad, your Lordship will also kindly see page 32, Malad, a formal order is there. All the facts are recorded therein.
32?
32, page 32, Malad.
Page 31, I think. P5, annexure.
Malad, in my
Lordship, this order is in favor of mine, Your Lordship. Because in this order, Your Lordship, the estate manager has considered the application of one person, Your Lordship, Jyoti Prasad Lahiri, your lordship. This order I was mentioning before, your lordship, that by the honorable court's order, your lordship, the estate manager has considered in the past. In the similarly placed situation, I am also there, your lordship.
Similarly placed?
Lordship,
Are you really similarly placed?
lordship, in the similarly placed, your lordship, I have annexed the order also, your
Because
lordship.
the will was executed after termination of the lease.
Lordship, but we do not.
This case has the same thing happened?
Lordship, but unfortunately, your lordship, they have not given the so cause notice. How could we can ascertain, your lordship, if the will has?
No one at that time, sir.
Yeah,
How can you get a show cause notice?
Lordship.
There was no will in your favor when the lease was terminated.
Lordship, when the it was terminated, before termination, your lordship, it is mandatory for them, your lordship, to give so cause notice. Your lordship, it is
You, to the lessee.
yes, lordship.
And you had no locus standi at that time, nor do you have any locus standi at the moment because it's a 72 termination.
Lordship, but if they have given, your lordship, it
That
must.
same case in the earlier matter?
Lordship, same, your lordship, same, exactly same. Yes,
show.
lordship.
That the will was executed after termination?
Your lordship, it has been considered by the Honorable High Court's order, your lordship, and the will has been executed because, your lordship, the knowledge of termination was not with the original lessee, your lordship. That's why the will has been given, your lordship, in favor of the petitioner. And your lordship, it must have been with them, your lordship, in the record that they have served the so cause notice. Your lordship, it has not been given. For that, I have came for before your lordship for consideration of my representative, if it can be considered, your lordship. For the principles of natural justice, your lordship, in the past, the estate manager, if the plot is not in use, your lordship, and if I am ready to comply with all the requisite formalities.
One instruction is necessary.
But kindly have a look. I know what is going through your lordship's mind, my lord, whether a notice was given or not. Kindly see 29, page 29. My lord, 29 is his application. He gives the probate. This and the probate is dated 1998. Kindly see, and my lord, kindly see the date. That is 2013.
Yes,
he comes up after 10 years.
Was the original lessee
Lordship.
aware that the lease was
Lordship.
terminated
Lordship.
before
Well,
granting probate?
It is
Please show me the document.
it is mandatory, your lord. Most humble submission, your
Original
lordship.
lessee should have
Most
been
humble.
served a notice
Yes.
prior to termination.
Yes.
If that was not done, the termination is not legal. And then he steps into his shoes.
My lord.
Yes. Well, that's one side of it. The other side is he makes an application saying that I have got a probate.
Yes.
When, Malad, kindly see 2013.
Because it was granted at that time.
No, you made your
My
submission.
lord.
At 2013, and he comes up in 2023 and says, now you give me the plot. But the conduct also, your lordship will see.
Lordship, the application has
The
been.
probate was granted in
Nine-
2013. must be.
Lordship.
98.
98 is the will.
98 is the will.
Lordship. It has been granted by the Honorable High Court on 2013.
The testament
And
has
Yes,
been
and Malad,
filed.
2013. Then Malad, my reply, the estate manager's reply is in 2014. He
Lordship,
does nothing for 10
lordship,
years.
after 1 year, they have replied, your lordship. I have, after obtaining probate, I have
He
made
does
the
nothing. He's
representation.
sitting there for 10
Lordship.
years. And now Malad, he comes up and says that no notice was given.
That is only on delay.
Lordship.
But please show me the notice.
Lordship.
If that is not given, the petitioner has a case.
For consideration of my representation.
But your lordship will pass an order, direct the concerned authority to produce the notice, because Malad, despite repeated requests, Malad, I have not received any instructions from them. I am placing my case on the basis of the records, what is available in the writ petition. Kindly pass an order directing them to place that record before your lordship.
Let me
Lordship,
see your
if
yes.
if my writ application can be considered by them as a representation, I will take lordship.
If you want to file a fresh representation, you can do that. But will it really help?
Lordship, for consideration only, I'm praying, because no knowledge was there to with the original lessee and
Let him
to
file a
lordship.
fresh representation before you let the authority consider. So I really have my doubts.
And kindly, Malad, specify there that he should take into consideration whether a notice was given to the authority. Very
Her learned counsels for the parties. Paragraph, it is submitted on behalf of the petitioner that Gaurango Chandra Sil was the
Lordship, original lessee.
one Gaurango Chandra Sil, comma, since deceased, comma. was granted lease in respect of the plot in question at Kalyani for a period of 999 years by virtue of lease agreement upon payment of requisite fees. The lessee executed a will in favor of the petitioner in respect of the said plot, which, comma, after demise of the lessee, comma, no, which and after demise of the lessee, comma, the petitioner obtained probate of the said will on 20th April 2013. Stop. The petitioner applied for mutation of the property in his name before the authority, which was turned down by the latter, LATTER, on the ground that the lease in favor of the original lessee was terminated in the year 1972.
রেস্টোরেশন হয়েছে হ্যাঁ হয়েছে তো কবে হয়েছে
অনেক আগে স্যার ক্যান ছিল স্যার ওটা রেস্টোরেন্ট হওয়ার পরে তো ম্যাটারটা এলো
Stop. Paragraph. Learned counsel for the petitioner submits that no notice was served upon the lessee prior to termination of the lease. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that the estate manager should consider.
Yes, he is the
Second
concerned
respondent
authority.
be directed
Yes.
to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the second respondent within 2 weeks
lordship
or a little more time.
no lordship I can submit
Weeks?
lordship regarding so cause notice your lordship
I will.
lordship
Within 2 weeks from date, stop. The second respondent is directed to consider and dispose of the representation within 4 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. In the light of the observation made by this court made in this order, including the fact as to whether show cause notice was issued upon the original lessee prior to termination of the lease. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof.
Much good.
Disposed of which actually.
Great. But kindly have a look. But this was dismissed once for default, whether it has been restored or not.
Thereof.
Yes, because we've been served with a copy of the restoration application. Yes.
Dismissal. It was restored.
Great.
Much good.
Next.
15.
Well, this is my application.
Amsan model is appearing in on state. He is on the way, due to traffic jam. Do not reach.
I am, your lordship, can you hear me, Malad? Thereafter, if he has anything to say. Well, this is a case of a.
The copy, the report in the form of affidavit.
Yes, I have got it, and I have given a copy last time. Mr. Mondol actually lost a copy. So I handed over that copy because he had handed over to me, and I,
File an exception to it.
not necessary at all.
Well, let me give you a date because he's not there.
My lord, this is a marginalized person, my lord. It's very difficult to continue with the cases because in the past occasions, twice it appeared and there were dates. If your lordship kindly takes up maybe tomorrow.
There was no steps taken on behalf of the petitioners.
Sorry, my lord.
On the last occasion, you did not take any steps on behalf of the petitioners.
On behalf of the petitioner.
That none appears for the petitioners on the earlier occasion.
We came a bit late. I'm sorry, my lord. I stand corrected, my lord. Definitely. But before that also there was some. But these are very poor people, my lord. Absolutely marginalized persons.
How does that really matter? Come back after. I'll give you a short date.
Can be taken up? No, no.
No,
I do not want to. I do not want to. But the paper is very much there, so I don't think.
Serve your purpose also.
Yes,
So
yes,
let it
yes, yes.
On prayer of the state respondents, the matter is adjourned. Paragraph. যিনি সব মুভ করছেন ওনার নাম দেবেন কিনা যিনি নেই তার নাম দেবেন আসেই let the matter appear under the same heading on 18 December.
18 December.
This side of the division.
Nice possession, my lord. Great.
2017 matter will
Well, very poor persons, my lord. Very difficult to accommodate for us, my lord. I'm grateful.
Sixteen.
16 to 26, same matter.
Same matter, my lord.
And I am appearing for the petitions, my lord.
I appear for the respondent railway authority.
Yes. Yes, what is the matter? You are for the petitioner?
I am for the petition.
Yes, what is the matter about?
But this is against the action of railway authority encroaching our land and residential plot. Rail was claiming that this land belongs to them, but we are in possession of 1947 deed, which clearly shows that the land is possessed by my ancestors and presently are possessed by me.
A joint physical verification.
Madam, may I make my submission? Madam, that was done. Madam, may I make my submission? Madam, only request praying with your lordship, my lord, kindly takes up item number 19. My lord. I have prepared my notes on the basis of item. So all are similar matter, my lord. I have prepared the paragraph will tally, my lord, because with my notes. If your lordship kindly item number 19.
19.
Yes, madam.
Didi এই ম্যাটারটা দিন তো WPA 5465
5465, yes.
19.
Oh, okay.
5465. Right. Give me 2 minutes.
In the meantime, may I?
Yes.
Madam, the petitioner has come up before your lordship, my lord, alleging that the railway authority has forcibly occupied their land and they should remove the boundary. That is the for my lord. And now I will place, my lord, from the writ petition, the paragraph they have made. My lord. Basically, my principal submission before your lordship that the case of the petitioner encroachment of land by the railway authority.
Yes.
The encroachment cannot be decided by the writ court. It is a disputed question of fact. My lord, that in that event they should go before the, my lord, appropriate civil court. My lord, this is my principal submission, and before that I will show to your lordship from their own paragraph. My lord, your lordship, this honorable court, my lord, initially directed to hold an inspection, and that inspection as a report is before your lordship. I shall place that report, and thereupon my lord again directed another inspection. And the second inspection, it has been found that in the LR records, the name of the petitioners are there, but the original records certified by the state government, this is of my lord, now.
5465.
And
Yes.
your lordship kindly peruse paragraph 2 of the writ petition.
Yes.
That the petitioner states that they have inherited the agricultural plot number such and such, measuring about such and such, and another plot of land measuring about such and such in Kalyani subdivision in district Nadia after death of the Madhav Pal on 3rd July 1997, being the husband and father of the petitioner. This is their basis of case. And now your lordship kindly peruse paragraph number 3. Your petitioner states that Madhav Pal had purchased the said plot of land from Aloka Ghosh, wife of Anil Chandra Ghosh, and from Homen Pal, son of Saurendranath Pal, on 13 March 95, by a registered deed by conveyance entered in such and such. Now your lordship kindly peruse paragraph 6.
Yes.
In this context, it is pertinent to mention here that as per land records and the Moja map, the railway authority has vast area of land along the up Shimurali line northern side of the existing railway track of about 62 feet, with measuring 10.4 acres of plot 766 under Khotian number 1 by 1 in Thaguna Moja, since acquired long ago. But part of the said land has been forcibly occupied by some influential persons, not by the railway, and land sharks, inasmuch as taking advantage of the unbelievable silence on the part of the railway authority, a lot of unauthorized construction has taken place on the said railway land over the years. This is the one of the case made out. But now your lordship kindly peruse paragraph 7.
Yes.
In view of the facts stated above, that can be sanely presumed that the then railway authority, while acquiring the land long ago, had reasonably contemplated the future need of expansion of railway track road, but due to language attitude on the part of these some railway officials, some unscrupulous persons have forcibly taken over the land over which railway authority has absolute and has used the said land by erecting shops, multi-storied residential buildings, eateries, etc. And for long span of time, the local railway authority remained mute spectators. This is their case, my lord. Now, paragraph 8. Surprisingly enough, in July, August 2016, a few persons claiming themselves to be the workers of contractors appointed by the railway authority stormed into the land and started demolishing the fence erected by the petitioners to save their crops from cattle and intruders, in as much as they started destroying the agricultural land using the mechanical device without any prior intimation and or notice to the petitioner. Their allegation starts against the railway. Now your lordship kindly peruse paragraph 22.
Yes.
It is pertinent to mention here that requisition and or acquisition of the land, even for public purpose, has posted a threat to the public body, and Railway Board, after realizing gravity of the situation, has issued a circular under their number such and such 17 December 2009, wherein it has been categorically mentioned that projects should be planned in such a manner so as to cause minimum acquisition of land, particularly agricultural land, and dislocation of landowners, inasmuch as it has been further contended therein that in projects other than new lines, railway PSU should review the proposed alignment, construction methodology to ensure that construction is content with existing railway boundary to the extent possible. These are the allegations. On the basis of this, my lord, his prayer is, your lordship kindly come to prayer, page 17, prayer A.
A read in the nature of mandamus commanding the respondent, each of them, agents, servants, and subordinate, to remove demarcating post from the land of the petitioner and return the forcibly occupied land. They are not asking for compensation for acquisition or that. They are saying that these are based on the facts, land search that they are developed.
Are asking for compensation also.
Your Lordship, a read in the nature of commanding the respondent, each of them, servant, and to compensation. That is my lord. That all right. Now, your Lordship, kindly peruse, my lord. Your Lordship's court directed, my lord,
The report.
inspection, joint inspection and report. The first inspection was held on 6th of November 2017.
Give me a minute, please.
Has your Lordship got it, my lord?
Give me a
Minute, just a minute. I am giving the reference, my lord. The back sheet your Lordship will get 27th of September 21.
September 21, yes. Yes.
In that report sheet, my lord, your Lordship will get inside joint note dated 6 November 2017. My lord has got it, my lord. May I place that report? On date, according to the directors, according to the directions of the ADM and the DL and LRO Nodia, his memo dated 8 June 2017 and 2nd November 2017, we, the undersigned, attended area, inspected the site situated between LR plot number such and such, the plot number are there, in question of returning the railway B land, excavated land, and present status of B land in connection with construction of third line in between Noihati Johnson to Ranaghat. Now, my lord, drawing inspection, we observe the following. This is very important, my lord. As per railway land plans, it reveals that all B land shown this plan resumed by government with exception of the portion colored red mark A. My lord, colored red mark A under construction engineer number such and such dated 16 February 1871. This plan is with me, my lord. To Board of Revenue by drawing number such and such, wherein certification has been made by the Assistant Secretary Government of West Bengal on 28 December 54 as per true copy of all other railway land plan as a plan in between Noihati and Ranaghat are confirming the same certification against B land are seen also. And I have got the, my lord, plan, and this is, my lord, it is showing that it is the railway land. Now, my lord, subsequently, when the matter was pending before your lordship again directed to hold another inspection. And now I place that inspection report before your lordship. That is, my lord, dated 14th of December 21, and another report, second report is there, and it has been affirmed by Anindita Ghosh Maiti. Has your lordship got it?
22nd June 2023.
Yes. The report is dated 14 December 2021. My lord, this has been affirmed by.
Yes.
My lord has got it, my lord.
Yes.
My lord, kindly peruse the joint inspection report. Second, pursuant to your lordship's direction. Joint physical inspection report in connection with the compliance with the High Court's order dated order related to WPA 5460 of 2017. In pursuance of the order dated 25th November 21 of the Honorable High Court at Calcutta in WPA number read with direction of the ADM and DL and LRO Nodia, by his office memo number such and such, a joint special physical inspection with railway authorities has been conducted by office of the BL and LRO Chakda in collaboration with the officials of the office of SD and LRO Kollani on 14 December 21 at 11 a.m. in LR plot number such and such. The plaintiffs of the said case were also present during the inspection. As a result of that inspection, the following findings has been revealed. In LR plot number such and such, as a result of ground truthing, it has been found that the plot of railway department does not infringe, transgress the suit LR plots, that is LR plot number such and such of concerned Moja. The width of railway plot is shown in the sketch map annexed here with offsets. Those offsets have been taken from midline of the existing railway track in the field. In case of LR plot number 785 in sheet number 2 of Mouja Saguna, as per boundary comparison of sheet number 2 of Mouja such and such of Mouja Madanpur, it transpires that the railway track in sheet number 2 of Mouja Saguna is running along the midline of the railway track of sheet number such and such. Here the plots of railway department does not transgress in the sheet number 2. The width of railway plot is shown in the sketch map annexed here with offset. Those sets have been taken from midline of the existing railway. In case of LR plot such and such, as per boundary comparison sheet number 2 and the sheet number 3 Mouja such and such, it transfers the railway track in sheet number 1 of Mouja is running along the upline of railway track of sheet of such and such. The shoot plot is commencing 350 away from the northern of Mouja boundary between Mouja and Mouja Saguna. Here the plots of railway department does not transgress the shoot premises. The width of railway plot is shown in the sketch map annexed here with offset. These offsets have been taken from upline of the existing railway track in the field. Well, these are the report, my lord. May I once, my lord? Place, my lord, the statement of the concerned officer. On in the, my lord, first paragraph, leave it, my lord, paragraph 2. As per the paragraph 2, as per the previous BL and LRO Chakda was present in the joint physical inspection with railway authorities 11 a.m. in pursuance of the order dated Rato, Honorable High Court at Calcutta in WPN number of that. The report was prepared in presence of Sushil Kumar Ghosh, Sudipta Ghosh, and such, Kollani, Senior Selection Officer, Engineer, Senior Engineer 2, Eastern Railway, Kachapara, and Mr. Dipendu Shaha, Block Land Reforms Officer, Chakda. I, as present Block Land and Land Reforms Officer, said and affirm this ability. I humbly, respectfully. These are the statement made with in support of this report. But my submission is, my lord, the report dated, my lord, 18th August 2007 is 18th August, my lord, first your lordship's court passed status quo order with respect to the land in question. That was the first, before your lordship, my lord, Justice Bagh, when his lordship there, passed the status quo order after hearing the party. Then, my lord, 6th November report, 6 November 2017, accordingly, a joint inspection was held wherein under point number 1, it was recorded that all B land shown in the plan, old railway map resumed by the government with exception of the portion colored red mark under construction and engineer's number such and such, wherein certification has been made by the assistant as a true copy. My lord, thereafter, during inspection, it is found that railway boundary pillars exist on the covered B land also. It is stated that, my lord, I am handing over this. This will be at the first report at just a minute. First 6 November 2017 report.
A copy of the first report has not been yet served with us.
Then you have to go through this in that.
On record since 2021. It has been submitted in 2021.
My lord, at one point of time.
Yeah. But 2017 report is not.
My lord has directed to. My lord has.
18th November 2021 was submitted.
That report is with us, but in 2000.
No, this has been filed earlier, 6th November 2017. এটা নেই আপনাদের কাছে?
না,
17.
দেয়নি কেউ কখনো আমাদের।
That report is also in annex to this report.
In that event, let them.
This joint note is annexed to the this report. 18th November 2021 report.
18th November 2021.
No, no.
It's a joint note annexed to this.
It is the earlier report of 2017.
হ্যাঁ সেটাই তো দেখাচ্ছি।
The joint note is on 2017.
Joint note with report. Joint note with report.
The note is annexed to the report. Report was filed in 21. The note annexed to the report is in 27.
Yes, I have understood. It is the same report.
Yes.
Not same report, different report. One, that
Two separate reports.
two separate report. My learning should say same report, not the same.
The Learned Council has the report.
আছে তো আপনার কাছে? No, may I place it? One second. As per railway plan, it reveals that all B land shown in this plan resumed by the government with exception. The B land, exception portion colored resumed by the government with exception of the portion colored red mark A under construction number such and such, where in certification has been made by the Assistant Secretary Government of West Bengal on 28th December as
You have not annexed the sketch maps to the report. That is the
that
difficulty.
is the
In none of the reports, the sketch maps are annexed.
that's a joint report. Well, I have not, the railway has not given opportunity to file any opposition to this. Well, the matter is taken up for hearing and
No, since you have filed a report and you have
this is a joint report, not only our report.
joint report, but you have filed this report. This report is
Not,
filed by the railway authority.
not my lord. This has been filed by the state authority. Your lordship kindly produce.
By the divisional railway manager,
My lord, that report
the
was,
railway authority.
that report was prepared unilaterally by the railway authority. It was not accepted. So your lordship, your lordship directed for a fresh inquiry and a joint inspection was conducted.
Second report, LR record found petitioner's name. Our case is, my lord, the original records, RS record shows railway property.
Let them come
My
with those documents.
Railway property. My lord, if they claim, my lord, LR record has been prepared behind the back of the railway authority, because if someone wants to change the name, then, my lord, the party whose name has been deleted, they should be given notice and thereafter order should have been passed. My lord,
My lord, let them show.
That is the provision.
My lord,
My lord, let them show a piece of record, a piece of record.
So they let us hear this.
LR records based
From the
unilaterally.
started, my lord. Then there is general notification, not for the individual.
Yes.
LR
My name is should be must give them.
Well, when the name of it is changed from the original record CS to RS, there should be a party who is affected, he should be given notice.
No, there's no provision for individual notice. A general notification is published when the record is
If
published.
my lord, I mildly consider if my name is there and that is changed, my lord, the authority is bound to give notice. That is not done on the basis of
Show me
general.
the provision.
Well, in that event, I shall show to your lordship, my lord, that provision, your lordship kindly take up next week. my
A
lord.
general notification is issued.
My lord,
Then,
for correction of
publication of LR record. Then a draft
only for
notice is filed.
for publication, my lord, not for changing, correction, inspection, my lord, hearing. After hearing that is made when the publication, for publication, my lord,
Come
not.
back to the provisions because there is a general notification, then a draft publication, then objections are
My
invited.
lord.
These are all general notifications, no
My lord.
individual notification.
My lord, but
And then a finalization of the draft publication. That's the procedure.
and they should come with the specific case with the before the railway authority that this is my land, this is my deed, and this is the recording. On the basis of this, I am entitled to. They have, my lord, a big application has been made before the lordship's court that once, my lord, they are saying encroachment and one they are saying, my lord, compensation. Encroachment, if admitted the railway has taken the plot, my lord, they are entitled to compensation. Railway is not that their land will
That
be.
was asked to be decided by the joint inquiry as to whether any portion of the petitioner's plot has been encroached upon by the railways. Utilized rather. Let us not use the term encroached upon.
Second,
Utilized by the railways.
there are vast area from Noyati to there are many.
Maybe.
Some plots have been. It is shown that the record has been changed, my lord, and there are other plots. There is no change of record.
Have you ascertained that you have not taken away any portion of the petitioner's plot? That was the purpose of the joint inspection.
LR record says in some area, my lord, the name of the LR record petitioner's name are there.
And
But
you
the,
have not challenged the LR records.
LR record I have not challenged because it has been changed behind our back. That is why you have not challenged.
Having knowledge, you have not challenged. So the LR record stands.
The LR record.
We have to abide by it.
LR record is a document of possession, not is a document of title.
And
so on the basis of
he is on possession. That
they are not in possession. Possession is railway. Railway and the land search as is submitted by. LR record, change of LR record does not give him a title of the property.
He is on possession. He is not on title.
He is not on possession. He is not on possession. He is only on the recording of the LR record. My submission, my lord.
I am in possession of the land. I am cultivating the land.
His case is it has been forcibly taken out, occupied by. One spell.
Possession. The LR record is in support of the petitioner. So how does the railway claim that it is there? It is in their possession.
Your lordship, kindly consider LR record is a document of possession, not is a document of title.
Exactly. Yes, no one says that it is document of title.
My lord, as on date, my lord, the land is in occupation. His statement is not correct that he is in occupation of the land. Their case is rail has occupied their land.
No, I have owned. I have owned that land.
Own is one thing, that is right title and interest.
The petitioners say that you have put in demarcating posts in the land.
Yes, my lord. So this is in our possession.
In possession of the petitioners. The LR record supports the possession of the petitioners. How do you substantiate your possession? There is nothing. No document.
Your lordship is, as of now, your lordship is relying on the LR record, not on the old railway records which are going to be.
What is that old railway record?
Record. I do not find anything.
That is this is here.
You have not annexed anything to your report.
That's in that event, we shall produce this before by your supplementary affidavit.
Pending for a very long time.
That is why I am sitting from the to do the case before your lordship. I have not gone to it. That is why I am sitting here. I am doing this case before your lordship. And your lordship kindly take this matter. I shall file this by a supplementary affidavit, and also I shall come with the prepare with the submission that provisions that hearing is necessary or not for changing the LR record.
Mr. There anything to add?
I shall give reply to that. Establishing my right.
Yes. Annexing all the relevant documents. There is no document in support of this case. Please file a comprehensive report in the form of an affidavit annexing all relevant documents.
As you.
And we shall submit an exception to that report.
Absolutely.
My lord.
Third learned counsels for the parties. Paragraph, it is claimed on behalf of the railway authorities that though the names of the petitioners appear in the LR records, the earlier records reveal that the railway authority is in possession of the plots in question. Stop. Paragraph, the said contention is denied and disputed by the petitioners who claim to be in possession of the plots. Paragraph, learned counsel for the railway authorities seeks to submit a comprehensive report in the form of an affidavit in this regard, annexing relevant documents. Paragraph, let the matter appear under the same heading on. Yes.
Including
The
the
report
pla-
is already on record.
including the plan.
That's the document. That I'll record, yes, yes. On prayer of the petitioner, Dr. Age, liberty is granted to use an exception to the report, comma, if required. Paragraph, let these matters appear under the same heading on 17th January.
Lordship, grateful to your Lordship.
Please exchange your reports and
In
exception
the
in the
meantime,
meantime. 2017 matters has been heard quite,
yes, sir.
for
Mine.
quite
And
some
that
time.
is why I am sitting. Well, twice I prayed for adjournment. I was.
প্রতিবার দেওয়া হচ্ছে ওগুলো দিচ্ছে না
না লাস্ট টাইম ছিল
ছিল আবার আজকে
আবার আজকে
Exception যেটুকু বললাম, liberty is exception, ব্যাস।
সিমিলার ম্যাটার, একটা রেসিডেন্সিয়াল, একটা এগ্রিকালচার।
কি বললাম? একই জিনিস তো। রিপোর্ট ইন দ্য ফর্ম অফ অ্যাফিডেভিট, কম্প্রিহেন্সিভ রিপোর্ট ইন দ্য ফর্ম অফ অ্যাফিডেভিট, একটাই। The report in the form of affidavit.
Grateful.
Till 26.
Till 26.
7. Item 27. 27. I am for the petitioner, my lord. The property belongs to a trust, and who is it? My lord, I'm praying for an adjournment, my lord. Since section 34, permission from district judge is pending, application is still pending, my lord. I'm praying for an adjournment.
Who is appearing for the respondents?
Mr. Shiv Shankar Banerjee usually appears for the ECL, and Mr. Siddiqui usually appears for the state in this matter, my lord.
You serve a notice upon the state? The direction for service of notice.
Previously, I've served. I'm not.
On the last occasion, there was a direction. Where is that service?
Not carrying the brief, my lord. Kindly pardon, my lord. I shall serve, my lord. Kindly grant me an adjournment.
Let it go out of list. Let the district judge decide first.
My lord, kindly remain it in the list.
Unless the district judge decides, we cannot proceed with this matter.
My lord, then liberty to mention may be given, my lord, because
Yes,
if
it
the
will be.
determination changes, my lord, it is difficult to list the matter. Sometimes,
That
my lord.
can't be helped. It is submitted on behalf of the, you're the petitioner.
My lord.
On behalf of the petitioner, that the application filed by the petitioner trust before the learned district judge is still pending. Paragraph in view of the above, let the matter go out of list with liberty to mention.
Eight.
I appear for the KMD. I'm of the state matters.
Petitioner?
Yes, come.
Anyone for the petitioner?
I'm happy to petition.
Yes.
There was a direction passed by Lordship's on the
Yes,
last
sir.
occasion.
We have filed one
That they are
report
like
from
to file
MD.
another
That,
Further report was called.
yes, ma'am, but that is not required, my lord. I can show to your Lordship. Your Lordship asked me to, my lord, show the entire plot has been acquired, my lord. The quantum of that. That is, my lord, I have annexed the documents in my report, where from it appears where the entire
Well,
plot.
I want to give exceptions to that report. Because I
The
have,
earlier report.
my lord, yes.
Let him come back. Learned counsel for the petitioners seeks to use an exception to the report in the form of affidavit submitted on behalf of the state respondents. It's on affidavit. Paragraph, let the matter appear under the same heading on 18 January
My lord.
2024.
In the meantime, I shall give
Nine.
But this is my application. Another point involved in this writ petition is because my as to whether I am entitled to interest under the section 18 of the Act of 2013. Admittedly, there is the possession was taken over and there was a delayed payment.
The proceeding was initiated, my lord, under the construction of Metro Railways Act
He's
1970.
appearing for the state.
There are sets of lawyers are there, my lord. There is in
Is it only the Metro Railways who's appearing?
yes, Mr. Railway, Metro Railway and Union of India is there.
My lord, I appear in 41, serial number 41, my lord.
This is 29.
Yes,
So these are all similar matters.
similar matter.
All
all
these
Similar matter.
29, no one. Metro Railway. Mr. Agarwal was appearing. Where is he?
Now, my lord, may I proceed with this, my lord, since my understanding is there, the all the law question of involved, or I can take up that matter also.
They're all together.
My lord,
Yes.
41, if your lordship takes.
We are only in 29 now. How can it
Yes.
become 41?
Now, the point your lordship has already decided in another repetition on the
Let us hear it. Yes.
yes. Now, my lord, fact remains that, my lord, on 22nd of March 2013, a notification under Section 7(1) of the Metro Railways Construction of Works Act 1978 was issued. For the project, my lord, New Goria to Titumit Station of New Goria, Damdam Airport project. Now, plot involved is my lord, plot number 2. And area is 4 decimal. Then, my lord, on 28th of June, in terms of the notice under Section 7(1), I filed my objection. That objection was overruled. Now, followed by, my lord, a notification under Section 10 was issued. Now, if your lordship kindly turn to Section 10 once.
You're referring to the 2013 Act.
2039. I am praying for compensation under the 2013 interest under Section 2013 Act, because I tell your lordship why. Because earlier, my lord, your lordship knows that in view of Section 105 of the Act of 2013, this Act was omitted for the purview of this 2013 Act.
Give me a minute, please. Didi, right to fair compensation. দরকার নেই হাবি যাবি বই রাখে রাইট টু ফেয়ার কম্পেনসেশন এখানে নেই এগুলোতে দেখুন ওটা হ্যাঁ ওই বইটা এখানে দিন
Lordship,
ওর পরেরটা yes
in this
Then-
matter, Lordship, I have one thing. In this matter, I am on behalf of the Mr. Satyendra Agarwal
yes
for the Metro Rails, and he is engaging another court. Kindly pray for not today, Lordship.
let this matter be made not to no it's a monthly list matter and order has to be
That is the thing.
let me fix a date in this matter. I'll hear the other matter.
Mel.
It will be covered
Mel.
on prayer of the respondents. The matter is adjourned. Paragraph, let the matter appear under the same heading. On 11 December, next Monday.
Mel. 11 December. Mel.
We can go for proceedings.
Hmm?
Next.
Grateful, Lordship. Brother, কোথায় যাচ্ছ? দাঁড়াও. Next matter is also, my lord, I understand Mr. Agarwal is appearing.
30.
Only 23.
Huh?
29.
29.
29.
30 তে নেই? Sure.
30 also I find his name.
Okay, Lordship.
You are Mr. Bijay Bagh?
No, yes, Lordship.
No.
What is your name?
My name is Gautam Malik. Satyendra Agarwal, Vijay Bagh.
Vijay Bagh.
But I'll not record his name in this matter because he's
Yes.
appearing from some other court. Who is Mr. Bijoy Bag? You are not the recorded advocate.
Yes, Lordship.
You are the recorded advocate.
No, Lordship, I am not the recorded Lordship.
Then
Vijay Bag is a
I have to
junior
record
of the
none-
district senior.
Hey, Joyto. None appears for the respondents. Agitati. What about this matter? Same order.
Same order, 11.
Same order, same date.
Next step. Okay.
11th. Next.
সেটা কোথায়? No, my lord,
Same.
it is also the same.
Agarwal.
No. That is Pulokesh Bajpayee, understand.
Very strange. Who is appearing? Same order. এগুলোতে জয়ন্ত একটা করে লাইন অ্যাড করুন. It is made clear that the matter shall be taken up for consideration on the adjourned date. It is made clear that the matter shall be taken up for consideration on the adjourned date, even in absence of the respondents.
দেখি আরেকটা দাও। ওটা কিন্তু my lord, 32 is
Respondents, anyone? Same order.
Mr. Agarwal is appearing.
Same order.
32 and 33.
33. Same order. Jayanta, protect same order. 34.
I'm appearing on behalf of the respondent, Your Lordship.
She is
Okay. দেখি 34 টা দাও।
Yes, so we can proceed.
ওদের অবজেকশনটা দাও।
Yes, you are referring to section 10.
Yes. Now, my lord, I kindly have a look at the, my lord, the section 10 ones.
Yes.
তুমি এই পাতাটা দেখো তো কবে কোথায় আমরা কি বলেছি ওই ইয়েতে আমরা কবে পজিশন নিয়েছি এটা কোথায় বলেছি ওটা আমাকে বার করে দাও ওটাতে বলে বার করে দাও আমাকে ঠিক আছে yes may I read out my lord? Where no objection under subsection 1 of section 9 has been made to the competent authority within the period specified therein, or where the competent authority has disallowed the objection under subsection 2 of that section. I submitted before lordship that we filed an objection, but that has been overruled.
Section 10 of
Or the Metro Railways Construction Works Act first.
Oh, I do not have.
Oh.
I'm on the 2013 Act.
No, I will come. I will come to that section, my lord. Kindly have a look at the section 10 first.
Do you have a spare book?
Yes, I have.
আচ্ছা ঠিক আছে
Yes. Where no objection under, your lordship got it. Under subsection 1 of section 9 has been made to the competent authority within the period specified therein, or where the competent authority has disallowed the objection under subsection 2 of that section. The competent authority shall, as soon as may be, submit a report according to the central government, and on receipt of such report, the central government shall declare by the notification in the office that the land, building, street, road, or passage of the right of the user, or the right in the nature of easement therein for laying the metro railways should be acquired. On the publication of the declaration under subsection 1, the land, building, street, road, or passage on the right of user, or the right in the nature of easement therein shall vest absolutely in the state of central government. Therefore, my lord, the moment this has been issued, publication under subsection, I lost everything. Neither I can use, nor I can do anything with that. Now, taking advantage of this subsection 2, my lord, they have taken possession of my land without, my lord, payment of compensation, and without taking possession of him without any notice. But fact remains, my lord, they have used my land, taking advantage of subsection 2. I tell your lordship why. If your lordship kindly have a look at the one information I got from the right to under the right to fair right to. Yes, kindly have a look at the my lord, our supplementary affidavit at page.
Supplementary affidavit.
Yes, my lord, pursuant to your lordship direction, your lordship they were kind enough to allow me to use a supplementary affidavit. Annexing these documents, my lord, I have used this
Give me a-
supplementary affidavit. Page 8.
Give me a minute, please.
My lord, my lord.
You have used an exception, I find.
Yes, I use the exception to the report.
Yes, and
But
then
my
again
lord,
a
I have yes, my lord, I have used a supplementary affidavit. Copy has already been served.
Lastly, I have not received that copy of the
That is very unfortunate that he is saying that she is not received, but I have a proof that she has served. Affidavit of service is also there.
It is after the exception.
Yes, after no, before the exception. Prior to exception.
Yes.
Extra copy আছে একটা?
এটা তো আমাদের exception.
না, extra
Yes.
copy আছে আমাদের কাছে একটা?
Supplementary.
Supplementary copy ওকে দাও।
Yes.
Now, if you lordship kindly turn to page 8 of the supplementary affidavit.
A copy of the supplementary affidavit.
No, your lordship,
Right now, I am handing it over.
Page 8.
I will hand it to you. Let me go
Yes,
through.
yes, yes.
Then lordship kindly turn to page 8. But this is the information I have received. Kindly have the mark. But I received from the Metro Railway. My lord, please inform from which month, because this is my information short for, which month and year the construction activities for the proposed Kobi Subha station building started for extension of the Metro Railway project from New Godia to airport.
The reply?
The construction report. Now this is the reply. If your lordship, the reply to go there.
Main petition.
Yes. Now, my lord,
Page 50
kindly turn to page 52
of the main petition.
of the writ petition. Kindly turn to page 52 of the writ petition.
Yes.
Yes.
The photograph.
This is the reply.
52 is the photograph.
Page 52, my lord, running page 52. There is
Photograph এর আগের page এ। আগের page two.
there is a, my lord, first one is the, my lord, that is, I have received from, this was forwarded to me by the PIO and Deputy Chief Engineer, Construction 1. Page 57, page 51. Oh, 52, page 51. That is the letter dated, my lord, 6th of December 2019 of the writ petition.
No, 52, 53, they are all photographs in the repetition.
Photographs এর আগের page এ।
No, before that photograph, my lord. Before that photograph, just one page before. The one page before for the first photograph.
Oh, this is 48, 49.
48, 49.
53 has been scratched out.
Oh, sorry,
And
my lord.
49.
Kindly excuse me, my lord.
Yes.
Now, this is the, my lord, kindly have a look at the signature of the gentleman who has forwarded this thing to me. That next page, before that page. My lord, this is PIO and Deputy Chief Engineer, Construction 1. He is supplying this information which he gathered from the, my lord, the Senior Deputy General Manager, HR. Because I will show your lordship from their from the report how he has dealt with this information which personally handed over to me. My lord, kindly see the page, next page, my lord. Please. Oh, এটা আমি আমারটা না তোমাদেরটা এসে পড়ছি। Yes. Please inform from which month and year the construction activities of Kobi Subha station building started for extension of metro railway project from New Goria to airport. Now, construction activities of Kobi Subha station building for extension of metro railway project from New Goria to airport was started from 10th of May 2016 in the acquired land. So therefore, my lord, I shown to your lordship, my lord, the section 10 and subsection 2. So taking advantage of subsection 2, my lord, they have started construction. So it appears, my lord, without taking over possession, they have started construction by taking advantage of subsection 2 of section 10. Then, my lord, you kindly see. Just now, Lordship, kindly turn to the Act of 2013 once.
Yes.
Now, let's turn to my lord, section 105.
Yes.
Subsection 1. Subject to subsection 3, the provision of this Act shall not apply to the enactment relating to the land acquisition specified in the fourth schedule. Then, my lord, subsection 3. The central government shall, by notification within 1 year from the date of commencement of this Act, direct that any of the provisions of this Act relating to the determination of compensation in accordance with the first schedule and rehabilitation and resettlement specified in the second and third schedule being beneficial to the affected families shall apply to the cases of land acquisition under the enactment specified in the fourth schedule. Now, let's kindly turn to the fourth schedule once. Has got it. Notification annex করেছি Let's kindly have a look at the item number 6 of the fourth schedule.
Third schedule, yes.
The metro railway construction of works at 1978. So initially, my lord, this was omitted. Then lordship kindly turn to section 113 of the new Act.
Yes.
Power to remove difficulties. If any difficulties arising in giving effect to the provision of the central government may by order make such provision to give such direction, not inconsistent in the provision of this Act may be appear is to be necessary expedient for the removal of the difficulty. Now, let's kindly turn to, kindly have a look at the supplementary affidavit of page 5. Well, this is the notification. Well, kindly turn to page 6. Ministry of Rural Development, dated 28th of August 2015.
Yes.
Kindly skip over the other things, my lord. Kindly turn to the paragraph starting just before now, therefore.
Yes.
And whereas, your lord has got it. The central government considers it necessary to extend the benefits available to the landowners under the Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation and Resettlement Act to similarly place land owners whose lands are acquired under the 13 enactments specified in the fourth schedule. And accordingly, the central government, keeping in view the aforesaid difficulties, had decided to extend the beneficial advantage to the landowners and uniformly apply the beneficial provisions of the Right to Fair Compensation Act relating to the determination of compensation and rehabilitation and resettlement were made applicable to cases of land acquisition under the state enactment in the interest of the landowners. Now, therefore, in exercise of subsection 1 of 113, I shown to your lordship, Now, this made the applicability of 2013 Act to the Metro Railway Act. Now, let's kindly turn to the order passed by the competent authority. আমাকে briefটা তোমাদের brief করতে থাকি। Yes. At page Malord, এটা মিলবে না তো মনে হয়। Malord 40 page 42 annexure P5 না জজ সাহেবের ওখানে তো মিলছে না তো 48 হচ্ছে প্যাজিনেশন তো গন্ডগোল আছে মানে পেজ 40 পেজ 5 annexure P5 এই দুটো নাম্বার কেন এই দেখ না 42 46
This is 39 here.
page 39
Yes.
This is an application under section 13(1) of the Metro Railway Construction of Works Act 1917, initially filed by the claimant Kishan M. Agarwal, being one of the directors of Agarwal Niket Private Limited, maintaining that the claimant company is the owner of 3 cutters, 5 cheaters, 4 square more commercial land under such and such. Now, my lord, I am skipping over these things. Now, my lord, it has been alleged that the claimant came to know the notification of government here such and such, my lord. Then next page, next paragraph, it is to be mentioned here that while the claim case under Metro Railway Act was in progress, in which it was initially instituted, the claimant on 5th of December 2016 filed a petition for amendment of claim application whereby he prayed for compensation as per 30 of 2013 Act. Accordingly, the said amendment petition of claimant was considered and allowed. Kindly mark this question, my lord, because they have taken in a petition, my lord, I find they have taken a plea that without making an amendment application, we sought for application for applicability of section 2013 Act, and this has been allowed. Although, my lord, they have not paid for any appeal against the order of the either of the competent authority or by the appellate authority. They have not paid for any appeal, although they have taken this plea. Now, on the other hand, OP Metro Railway Kolkata appeared by filing Vokalanama and denied all the material allegations set forth in the claimant application and specifically prayed for dismissal of the application on the ground of non-maintainability of his claim application, having no cause of action for filing this application. The application has not been supported necessary document along with other ground mentioned therein. On the basis of the pleadings of the parties, following issues were framed to reach the just decision of this case: whether the claimant's application is maintainable in law, whether there is any cause of action for filing this claim application, whether claimant is the owner of the scheduled land in question, whether claimant is entitled to receive any compensation under 30, what compensation claimant is entitled to receive. Then, my lord, reasons were given, and kindly turn to the inner page 5. You also got it. Further, by banking upon subsection 3 of section 30, the right to fair compensation, transparency, land acquisition, rehabilitation, resettlement Act 2013, insists to allow 12% interest from the date of notification to the date of taking possession on the special impact assessment study under section subsection under section 4(2) of the said Act, and for loss of business. My lord, I understand, my lord, this noting is incorrect. Because 12% says, my lord, this is a additional compensation, additional land value, not interest. Because interest is being dealt with under section 80, which is akin to, my lord, section 34 of the Act 1 of 1894. Now, my lord, lawyer for the banking upon Exhibit 13, wherein Department of the Land Resources and Ministry of Land Development, Government of India, cleared by its order dated 26th of October 2015, my lord, that notification I shown to your lordship, my lord. The reference date for calculating at the rate of 12% should be the date of preliminary notification under Land Acquisition 1894, and the department to this there is no other reference date that can be treated as equivalent to date of such and such. So the claim of interest at the rate on the total compensation amount from the date of preliminary notification as claimed by the learned lawyer for the claimant cannot be washed out in the present case, as the statute itself cleared this provision. Thereafter, DO number such and such dated 26th of 2015 established the claim interest as paid for. In the present case, the preliminary notification for acquisition published on 29th of June 2013, and as such the claimant is entitled to get interest at the rate 12% from the date of 9/6/2013 till the date of delivery of the judgment. But kindly have a look at the, my lord, the subsection 3 of section 30 of the Act of 2013. Okay.
I have the book.
No, my lord, my learned friend has, he's searching from mobile.
Yes.
So,
Thank you.
yes. Kindly turn to, my lord, this provides for award of solicium. Then subsection 3.
Yes.
In addition to the market value of the land provided under section 26, the collector shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of the publication of the notification, in addition to the market value. Not, this cannot be termed as, my lord, the interest. So what he has proceeded with, as if I have received the interest, so I am not entitled to have any interest. So, my lord, he said, ultimately, he said that I am not entitled to any other relief as paid for. If your lord say, I skip over because he has admitted, my lord, the market value, etc., my lord, I prefer an appeal disallowed. But what I am on is this, my lord. At inner page 9.
Yes.
My lord, my claim was accordingly allowed from inner page 8 last paragraph. He has allowed, my lord, the market value, and, my lord, kindly see, my lord, page 9, interest at the rate of 12% per annum. This is incorrect. This is additional compensation, and that's why he has said, my lord, in the last in that paragraph, my lord, and he is not entitled to get any other relief. I shown to your lordship, my lord, that possession was taken over in the month of April 2016 from the RTI. And this order was passed, my lord, on 28th of December 2017. This is the date of the award.
Yes.
Because this is the, my lord, the date of the award. Now, my lord,
12% has been held to be interest in this order.
my lord, it is held to be the additional compensation on the market value because it's the beneficial legislation. And a statute says, my lord, this is not interest. Because if your lordship kindly turn to, my lord, the section 81. Section 81. It specifically provides for, that is, my lord, provided for award of solicium. In that provision, my lord, there was a provision for additional compensation. Now, kindly turn to section 80.
Yes.
Payment of interest. So, section 8, payment of interest provides for section 80 only. But when the amount of such compensation is not paid or deposited on or before taking possession of the land. So, what is the condition precedent, my lord? That before taking of the possession of the land, I have to pay or to be deposited with the competent authority by the railway. Because, my lord, why I am saying this? If your lordship kindly see section 11 of the Metro Railways Act 1978.
Yes.
Where any land, building, street, road or passage has vested under subsection 2 of section 10 and the amount determined by the competent authority under section 13 with respect to such land, building, street, road, passage has been deposited under subsection 1 or section 14 with the central government or with the competent authority. Then only they can take the possession of the land. But here, my lord, what they did, taking advantage of subsection 2 of section 10, they have started using my land without taking actual physical possession. And what they did, my lord, when they were handing over the check, they said, you sign over here, I will, otherwise I will not. I was compelled to sign in the possession certificate. Yes, this is the possession certificate. Although my signature is not required because you have to serve notice. I have to direct it to be handover. If I don't comply, you can take appropriate action against me in terms of section 11. If I fail to comply, there is hardly any scope for my signature in the possession certificate.
When was the compensation paid?
Well, compensation paid afterwards. That is that after the
So even if it is held that possession was taken,
yes,
still then the same situation is the
same
remains.
situation.
The same situation remains. isn't it?
Yes, same situation, my lord, because I was paid
What is important, what is relevant is the date of compensation.
date of compensation from the date of possession, because section 80 says from the date of taking over possession till the payment,
Yes.
or deposit with the competent authority, whichever.
Possession was taken in 2016
2016, because that is their own case.
and compensation was paid much later,
Much later,
not even within 1 year.
September 20.
September 2019.
So 12% and the both the like 15% interest is also
It's 9% for 1 year and 15% for the rest.
Yes.
For the rest period, I am entitled, because I tell you, lordship, why? Because I needed to claim for compensation interest at all. Because earlier occasion I submitted, I placed before a judge one judgment of your lordship, that this is nothing but a mere arithmetical calculation, not even the discretion of the court. If your lordship kindly see one judgment reported in, my lord, yes, no, no. Yes, that is, my lord, reported in 2007 to 2007 volume 2 SCC page 3. Yes, page 341. Firstly, I am placing, my lord, the 1-2 lines from the footnote, from the note. The lordship will find the section 23 is akin to, my lord, the section 30.
Yes.
And, my lord, interest on amount payable by way of additional amount and solution, grant of, is automatic and does not involve any judicial discretion. But he is saying that I am not entitled to any other relief. Without discarding or without disapproving that no possession was not taken over on that day. So therefore, all are you are not entitled to the interest. There is no delay in making the payment. He has not said so. Now, my lord, if your lordship kindly to the relevant paragraph, I will not trouble your lordship to go through the entire judgment. That is at page 349.
Compensation was paid only after this judgment, is it?
Yes, because until and unless your lordship knows, my lord, akin to section 11, without inquiry, after inquiry, award declared, then tender payment. Here, my lord, they had to deposit with the competent authority. Competent authority will pay to me. If your lordship kindly see, last paragraph, my lord. The High Court is bound to award the interest on the additional amount payable under section 23(1)(a) and solicium payable under section 23(2) of the Act. Moreover, grant of interest on these amounts is consequential and automatic and involves only arithmetical calculation and not application for judicial mind or exercise judicial discretion. And one judgment I like to show your lordship why I am saying this. Section 80 is akin to section 34 of the Land Acquisition Act. My lord, sorry, my lord. Yeah, I have shown to your lordship the many times your lordship has gone through this. That in the 5 judges been judgment. This is a volume. Only I like to draw your lordship kind attention to paragraph 205. This is this is the judgment I am relying upon. That is, my lord. Yes, 2020 volume 8 SCC 129. My lord, let's kindly have a look at the paragraph 2005. My lord, this was the matter which was referred to the special bench in connection with as to whether the applicability of section 24 subsection 2, because Pune municipality held otherwise, and that's why this was referred. In deciding those issues, my lord, a question was cropped up pertinent to, my lord, the applicability of section 34 in section 80. That has been dealt with, my lord, in paragraph 205.
Refer to this, refer this judgment earlier.
Yes, yes. My lord, in the RB dealer's case, my lord, your lordship had dealt with this.
Please give me a copy.
My lord.
Because I have to refer this here also.
Yes, yes. My lord, I will. Definitely, I will. My lord, I will xerox. My lord, yes. My lord, I am handing up a copy. Right.
Fine,
এবারে দেখি ওদের রিপোর্টটা দেখি ওদের রিপোর্টটা দে ওদের রিপোর্টটা কোথায় দিয়েছে এটা ওদের রিপোর্টটা তো ঠিক আছে আমাদের এক্সেপশন
That's all.
No, just I like to place the report they have filed. The report they have filed, my lord.
Yes, I was also actually wondering what is there in their report and what is their stand.
Yes, yes. Now, my lord, kindly have a look their stand. I like to place before your lordship. My lord, kindly remember, my lord, I shown to your lordship that who has issued this information to me under the Right to Information Act. Yes. That same gentleman, if I am not wrong, subject to correction of my learned friend, affirming this report. Brijbhushan Prasad Kuswara, son of such and such, working as Deputy Chief Engineer, Headquarters, Metro Railway. I hold the designation of Deputy Chief Engineer, Headquarters, Metro Railway, Kolkata, and representative of the respondents. Now kindly see. He has admitted my case so far paragraph 1A and B is concerned, my lord. He has annexed the report, the annexures. Then he has said, B, the central government neither added nor omitted to any other enactment in the notification, and the notification only was to be governed under the Railway Construction Act 1970. I could not, really speaking, my lord, I could not follow this language. Either he say that it does not apply, or he has to say that this is applicable. Because this notification, my lord, so 2016 notification, my lord, 2015, 2016 notification, my lord, was there before that, there are two notification, ordinance, one by another, then this removal of difficulties order was passed. Then lordship kindly see, then he had quoted the such and such fourth schedule. Subparagraph C. I shown to your lordship, I filed an application for amendment and that amendment was allowed. Why I request your lordship to mark that portion because of subparagraph C.
Yes.
That the petitioner filed claim registered under as NGA 20 or 2014 before the learned competent authority seeking compensation under the Metro Railways construction as and such. But during the pendency of the claims, the claimant had, without serving the Metro Railway, had amended illegally and seeking compensation. Well, if that be the case, they have not preferred any appeal against that. Moreover, in the order sheet, my lord, they have this has been filed, stated that I filed an application of amendment and that has been allowed. In spite of that, Metro did not take any steps by preferring an appeal against that judgment of the competent authority. In spite of that, he is writing this. Had admitted illegally and seeking compensation as per section 30 of the right to such and such, whereas the notification did not deal with the said 2013 Act. My lord, here also I have respectful submission. My lord, I am asking the compensation under section 13 of the Metro Railways Act. Only, my lord, determination is to remain under section, not I am asking for compensation under section 30. The provision of this Act 23 does not apply to the issued notification. The notification has been issued under the Metro Railway Construction Act. There has been no modification to the notification and no other acts are included in the notification. He is a government official, my lord, under railways, under the Ministry of Railways. And he is ignoring this, saying that he is criticizing that order otherwise. Next. And in fact, my lord, he has not preferred any appeal. So at this juncture, he cannot take this plea. The petitioner has sought a huge compensation with development cost and statutory interest and other inflated claims. There has been a huge difference of excess claim assessment under the new amendment claims under the Act 2013 and to the extent extract the amount. The claims cannot be decided on 2013 Act 2013. The competent authority exceeding the jurisdiction. The tribunals and the quasi-tribunal bodies cannot go beyond the statute. If the tribunals or quasi-tribunal bodies travels beyond the statute, they will be liable to be set aside. Now, in my writ petition, manner subject to your lordship correction, in my writ petition, wherein I have, can he claim this? I am putting it to myself. He has not preferred any appeal. Moreover, I shown to your lordship, Mala 2013 provisions of beneficial legislation, and he is criticizing the own higher authority. That the learned competent authority has framed issues such and such, then, my lord, he has said. Now, kindly look at the last paragraph. My lord, E. My lord, skipping over the first 3-4 lines, my lord, and what starts with and as such. Your lordship has got it. After 6-7 lines, as such. As such, the question of further 5 lakhs per quota cannot be reasonable and justified to consider. Further, question of expenditure incurred by the petitioner company for development of security personnel and business loss, as has been mentioned in his affidavit without any supporting document, is appeared to be made on the conjuncture and summarized in is also cannot be allowed without clear, cogent, convincing evidence in support of such claims. So, in the present case, petitioner is entitled to get total compensation including interest 3,09,000 and he is not entitled to get any other relief. The petitioner neither did not raise any issue under section 80 of the Act, neither had claimed that he did not produce any document or evidence in such claim, and the petitioner filed his appeal. Now, Hasimala, I shown to your lordship just here and now that I need to claim. It's a because possession taken over. How could I say before the authority that you pay compensation from this paid to that until and this is deposited with him? That's why, my lord, my way of understanding of the Supreme Court judgment is this, my lord. That's why I said this is an arithmetical calculation. That is the reason. Because after deposit, then question of payment. So I am not aware as to when this will be deposited. How could I claim the exact amount? Then Lordship kindly see, in the pendency of the petitioner, filed an application under Section 80 of the 2013 Act. The appellate authority rejected the application on merit under Section 80 with reason that the appeal is continuous process of the original case, since the claimant had filed the appeal challenging the common authority about compensation amount. So in the instant appeal, there is no scope for implementing Section 80. Well, subject to your lordship correction. If somebody prefer an appeal against your lordship's order before the division bench, and ultimately division bench held your lordships, then I am not entitled to the interest. Well, interest is something different and the merit of the appeal is something different. So rejection of the ground is this, my lord, this is a continuous process. There was no stay that you need not to deposit the money.
This appeal is against which order?
Against the competent authority order. I have annexed that. I will show that document. So, my lord, there was no stay. And Metro Railway authority was under the obligation to deposit the amount with the competent authority in terms of the competent authority order. You cannot say, since I have prepared an appeal before the appellate authority, so I need not to deposit. No.
And the order was upheld.
An order was upheld. In spite of that, he is saying that it's a continuous process, so I am not entitled to Section 80. Although, my lord, Section 80 is completely different from the taking over possession till the payment. And in between, if there is a stay, that period will be, my lord, exempted. And that is not the case. One hand, you are in the RB dealers case, your lordship have dealt with. One hand, you are taking advantage of the Section 2. You have said, the moment this has been vested, I have the easement right, everything. I don't have any right to even enter into the possession. Vested with the central government. On the other hand, you have said, no, possession has not been taken over. So how you have carried out the construction? Then, my lord, this is the next, my lord, I. Why I am harping this I, my lord? That for the first time, RTI query dated November 2019 before the Rail Vikas Nigam Limited for fishing in troubled waters and motive to extract more amount had made a RTI application dated 21/11/2019, where the claimant has sought for information that from which month and year the construction activities of Kobi Subhas station has started for extension of metro railway project from New Sajat. The reply was dated 30/11/2019 that construction of Kobi Subhas extension of metro railway from New Godia to Atto in the acquired land of the metro railway within the existing railway boundary. This RTI does define in general construction taking place. An order not defines any particular area or plot. Well, can they see the self-contradiction itself? One hand, you are saying acquired. Land acquired under the notification. The moment you have issued notification under Section 10, land acquired. That is the language of the statute. And you are saying that you have started construction on the acquired land. So this is the plea now they have taken when you could have said, so no construction has been constructed on your land. So this is the only plea, my lord. And I have asking this interest matter, which is a statutory entitlement for extracting the money from the metro railway. Anyway, and that the metro railway kindly now the M. This is important, my lord. Why your lordship has put me a definite question when this money was paid or deposited. The answer is, my lord, at page 7, M.
2019.
That is the date 12th September 2019. So, my lord, my respectful submission before your lordship is this, my lord. that April 2016 to 12th September 2019, I am entitled to have the interest under Section 80.
Here again, they say position taken on 12th September 2019.
That exactly what I am on. But can't be. Because you have started construction, I have annexed in my supplementary affidavit, my lord, the nature of construction.
Let the railways explain.
Yes.
Construction in 2016, possession in 2019.
Yes.
Lordship,
Explain this fact, madam.
yes, Your Lordship. In respect of the RTI, Your Lordship, which my senior has referred from the writ petition page, I guess, Your Lordship, there is a mismatch of the page. Reply to the RTI, Lordship. There is mentioned that construction activities of Kabishuva station building for extension of metro railway project from New Goria to airport was started from 10/5/2016 in the acquired land of metro railway within the existing railway boundary. Lordship, in regard to that, the plot which we have acquired and which we have are in question, Lordship, that plot has been taken. Obviously, that has been taken and construction was also initiated, but not in the particular plot which we are representing right now. In the RTI, Lordship, there is no mention of any particular plots. Like the RTI defines that general construction has been taken place, Lordship. And the order does not define any particular area or plot, Lordship.
It is in reply to which question, which query?
In the query where they said that the position has been taken in the year 2016 as per the RTI reply dated 30/11/2019, Your Lordship. General construction has been started, but it doesn't. The reply contains that general construction has been started, but it doesn't.
Stated that general construction was started.
Lordship.
Because you have stated that in the acquired land of Metro Railway.
Yes,
it
Your Lordship.
includes the petitioner's land.
Yes, Your Lordship.
So where do you indicate that the petitioner's land was not touched?
No, it has not been indicated over in the reply, Your Lordship.
How do you say that without an indication in the documents?
Yes, Your Lordship, but they have asked the question in respect of that particular plots, that which month and year the construction. They did not ask for any particular plots. They asked for the entire project, Your Lordship.
And your reply is with regard to the entire
project.
Acquired land.
Yes, Your Lordship.
It includes the petitioner's land.
Yes, Your Lordship, but it doesn't define that whether the plot of the petitioner in this petition has been taken position or not, Your Lordship. And my next point is that, Lordship, the competent authorities order dated 28/12/2017, which was went for an appeal. An appeal order was passed in 13/3/2019. As per the section 80 of the Right to Fair Compensation Act, Lordship, the amount need to be deposited after passing the order or before taking possession, Lordship. After passing the order, before taking possession within 1 month. So, Lordship, in that regard, when the appellate authority passed its order on 13/3/2019, and the award claimant was amount of rupees 3,12,13,774, which was accordingly deposited on 11/6/2019 without any delay. And thereafter, the possession of that particular plot, which has been mentioned in this petition, has been taken on 12/9/2019, Lordship.
Start construction first and take possession later.
No, Lordship. In this regard, in this petition, only the particular, I'm just only taking plea in respect of the particular plot which has been mentioned in this writ petition, Lordship. That I have taken possession of that particular land after making payment to the competent authority and an amount as has been mentioned in its our appeal award dated 13/3/2019. And accordingly, I have paid that amount in 11/6/2019. And thereafter, I have taken possession in 12/9/2019, Lordship. So accordingly, we acted in terms of the prescribed statute which has been mentioned in the Right to Fair Compensation Act, Lordship. So therefore, my plea is that petitioner is not entitled to get the interest under Section 80 of the 13 Act, Lordship. That's it.
That's all.
Yes, Your Lordship.
Good, crisp submission.
I will not repeat myself.
And my senior friend has described all the particulars in regard to my report and in accordance with his supplementary report. So therefore, I just only have these two submission in respect of that lordship. That's it.
My learned friend has said that only my portion, that particular, that plot. That's why all the matters has been tagged together. Because all the lands side by side. And you are using my everything for the purpose of construction also. You have used my land. Why I have been dispossessed. Otherwise, without using those lands, you cannot construct the construction.
That's all.
And yes, my lord, and also, my lord, this is the
Mr. Pond, one thing, because all the matters are related.
yes.
And first few matters I have fixed 11 on 11. So I would like to shift these matters also to 11, because if I take a decision in one matter, it will cover all the
My
matters.
lord, I will. Only thing is this, my lord.
The respondents should get an opportunity.
Yes,
to
my
hear.
lord. In this, also, my lord, I like to rely the judgment delivered by your lordship, because I was under the expression that they will prefer an appeal. But till today, they have not preferred an appeal, although few months have passed. So, we will, so, my lord, I will hand up a copy of those judgment to my learned friends so that they can go
On
through
the
it.
next day,
Yes,
please.
because I will rely on that judgment, because in the self-same project. This is also in connection with the self-same project.
I have filed my report. I have given details.
It's the same issue.
The same issue, but dates I have given. When the competent authority decided to, then when the appellate authority decided to, when the compensation, and thereafter when the money was withdrawn. And this is the section 80 of the fair compensation, payment of fair compensation. Because under the 80 the interest claim, that is after from the date of the.
That is, I believe, the only claim in the writ petitions.
Yes, yes.
All these writ petitions claim interest,
Not section.
because compensation has been admittedly taken.
Yes, your lordship.
Only prayer has been made. So here, my lord, if the possession, my lord, has been taken after payment of the entire compensation, then there is no accrual interest in terms of the section 80.
Absolutely.
Therefore, my lord, if anything scope is broadened, then that has to be amended. Not here, it is not. It is in section 80 scope is that this interest.
Section 80, it's very clear.
And here, my lord, in my case, taking over the possession of the land, my lord, that is signed by the parties. And that is after payment of the entire compensation before the competent.
But you admit that you started construction in 2016.
Never, not the construction, not is a huge land.
It is admitted in
the airport, and therefore not in the process.
Can you show any document to prove that you started construction on particular lands before payment of compensation?
In my plot, my lord, construction is taken.
So
this is not in the beginning of that construction, from where the construction is started.
Any document to show that?
That I will make it well.
Please show.
I will make
Since your RTI reply says construction started in 2016 in respect of all the acquired plots.
Yes.
Now, all the acquired plots includes all the plots involved in all the repetitions.
Construction cannot complete in 1 year.
One.
This is started in 2016. It's a process. It has to go up to Dam. So therefore, it started from Oriya.
So you cannot take possession of a portion of a plot in 2016, remaining portion in 2019. That is not the railway project.
As and when required, land required, steps taken, not at a time.
Please come back.
So, my lord,
Not very convincing, I am afraid.
I will hand up the I will hand up the judgment.
And so far, not that when the construction started, in particular in my case, that I will make instruction.
So according to you, plot A, you take possession, start
Yes.
construction. Then you go to plot G, you take possession, you start construction. Plot C, you take possession. That's impractical, sir.
Here, compensation.
Acquisition is by way of a single notification.
That is in the process, and before that, possession not taken. Possession not taken. Maybe the measurement made outside. Scratch made, but not that possession taken for construction. Construction not started.
Difficult. Please come back. If you have any further documents to produce, please come.
Kindly,
Pleasure.
direct that.
No.
No further
No.
direction. I'll just fix it for further consideration.
Yes, Your Lordship.
Or do you have filed a report, which in my opinion is sufficient?
Kindly.
But then you are going beyond that.
Supplementary affidavit so that I will say when the construction
Just a minute.
the plot.
In each of the plots?
I am concerned with the plot. The
Then?
41 plot.
Supplementary affidavit will not suffice, sir. The document needs to be produced.
Produce the entire records then. Let me check up.
On the metro railway, when the construction started, whether construction started on this particular plot, and if there is any documents that will be annexed, my lord, or it will be, my lord, stated on affidavit.
That will
Yes.
not be sufficient. That is what I want to indicate. There should be documents. You have already stated on affidavit when the construction has started.
Yes.
That is not sufficient.
My lord, construction
If
started
you
from
have,
the beginning, lord.
if you have particular documents to show the date on which construction has started on each of the plots, this is applicable for you also, madam.
Yes, Your Lordship.
So the court will consider. I'll only fix a date for reconsideration. Come back on the same date, in fact,
Yes.
because other matters have been fixed on 11th. So
Yes.
please come back on 11th. Let us.
Yes.
Yes, Your Lordship.
If you want to come back with documents, I'll grant you liberty.
Yes.
You need to see whether you have such documents at all.
Yes.
I will make inquiry. From
Yes.
Metro Railway, I will make inquiry.
Please do
There
that.
is document.
Please do that.
The
Please do that.
construction
Yes,
started
okay.
on that particular plot, so that can be provided.
Yes.
Because what you say is construction started on each of the plots on separate dates,
Yes, Your Lordship.
according to you.
Yes, Your Lordship. Yes.
Separate plot, separate.
So unless that is shown before the court, that is
Yes,
substantiated,
Yes.
the court will rely upon your RTI reply,
All right.
which covers all the acquired plots.
All right, Your
Yes.
Lordship. Yes. Yes, Your Lordship. I
Have
will
an
ask the
opportunity, please
department.
find out.
Sure, Your Lordship.
For learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration on 11th December. I'll call the matters. One. I'll call them quickly. Didi, forward them. Same matters. Gulo. Is appearing for the respondents with the other matters.
37 থেকে দেখো 37 থেকে দেখো 37
আমি জানি
সেম ম্যাটার গুলো রাখতে বলছি
35 ডেকে দিন পরপর ডেকে দিন।
আপনার ম্যাটারে অন্য অর্ডার
35. 35, my lord, I am for the petitioner.
Yes.
Under the petitioner, 35.
This is a separate matter, I think, isn't it? A different matter. 35, I'll just make it not today.
Oh, 35, I am for the petitioner.
35 is a different matter.
Yes, yes.
Different matter.
I'm taking up a chain of certain matters. I'll just make this not today. I want to call the similar matters.
My lord, kindly fix the matter on another day.
So not today only. 37. From here again, the same matter.
Yes, yes.
State who is appearing? 37.
I'm on behalf of the Mr. Satyendra Agar, pray for not today, Lordship.
You're appearing for?
Mr. Satyendra Agar for the Metro Rail.
No, his name cannot be recorded because
No
he is
one's
in-
name can be recorded.
Yes.
Omlan, none appears for the state respondents.
No, Union of India.
Metro
but Metro-
None appears for the respondents. Fine. None appears for the respondents. Let the matter appear under the same heading on 11th. Paragraph, it is made clear that the matters may be taken up for consideration on the adjourned date, even in absence of the respondents. You are in 43 only.
41.
41 এ respondent উনি আছেন ওনার নাম record করুন। Give your name. So this is still 47.
Yes, and all the matters, I understand Mr. Agarwal is appearing.
Yes, Lordship.
Yes.
Please request him to appear on the next date, otherwise it will be taken up in his absence. Right?
স্যার 2 মিনিট সময় চাইছি আমি। আমার একটা রিট পিটিশন ফাইল হয়েছিল তো 18 এপ্রিল 2023-এ। তো
আপনি
আমি
নিজে ফাইল
ভীষণ
করেছেন না আপনার কোনো উকিলবাবু
উকিল
আছেন?
উকিল উকিল
আপনার
উকিল
যদি
করেছেন।
উকিলবাবু থাকেন তাহলে আমি আপনার কথা এভাবে শুনবো
আপনার
না।
উকিলকে নিয়ে আসুন,
আপনার
আমরা উকিলকে
উকিলবাবুকে বলুন বলতে কোর্টের কাছে।
আমরা উকিলবাবুকে নিয়ে আসুন।
লিগাল এডের মাধ্যমে উকিল
আরে
পেয়েছি ম্যাম।
উকিলবাবুকে নিয়ে আসুন।
উকিল বাবু তো আমাকে বলছেন এখনো পর্যন্ত ইয়ে নাম্বার
ঠিক
আছে।
আছে, উকিলবাবুকে বলুন মেনশন
আপনার
করতে।
উকিলবাবুকে মেনশন করতে বলবেন কালকে সকাল 10:30টায়।
কাল 10:30টার সময় উকিলবাবুকে বলুন
10:30টায়
মেনশন করতে।
উকিলবাবু আছেন, আমি আপনার কথা এভাবে শুনতে পারি না। ঠিক আছে, আপনার উকিলবাবুকে বলুন কালকে 10:30টার সময় কোর্টে এসে
কালকে
হ্যাঁ, আগামীকাল। হ্যাঁ, obliged.
file this read petition, my lord. Day after tomorrow, my lord, the construction will be demolished, my lord.
It's not the mentioning time. Please come back.
My
to
lord,
the
leave to
mentioning
file
time.
this read petition, lordship.
Please show me the notice.
Wednesday, my lord, the date is, my lord, to demolish, my lord, within 15 days, my lord, 22nd 11/2023, my lord, the notice has been issued. There is a colony, my lord, in Shantipolli, in Howrah, my lord, that has, the property has been provided by the Refugee Rehabilitation Department, but subsequently, the BDO has issued this notice, my lord, they have.
File and come back. No date has been fixed for eviction. Please
My
do
lord,
not make these submissions.
Today, my lord, is 12, my lord, day after tomorrow, my lord, is the
The
date.
date of eviction stated.
My lord, the date is not specified, but the notice issued, my lord, to 22nd 11/2023. And the, my lord,
Requests you to vacate the land within
15 days, my lord.
Otherwise, necessary steps. So where is the date of eviction on day after tomorrow, as you said? Please do not make wrong submissions.
My lord,
File and come.
today is 12, my lord. Day after
So?
tomorrow is just, my lord,
Where is the date
15.
of eviction? It is not the date of eviction.
My lord,
File and come.
lord.
No leave is required. এটা ফেরত দিয়ে দিন দিদি। Yes, call the raise list, please.
Group 7 motion 626.
এটা ফেরত দিয়ে দিন। লিভ দিতে হবে না।
This brief has been entrusted to me today itself. Let it be taken up tomorrow just. Because there is a can also. It has been handed over Mrs. Sinha
This is
today.
626. 626.
Madam,
Group 7 motion.
E-rickshaw matter.
Supposed to that, it has been handed over today itself. Let it be taken up tomorrow, but I just
Not today,
only not today, only not today.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading. কালকে দিন।
My lord, I will.
5th December.
Six 27.
Huh? Yes, petitioner.
My lord, I am for the petition.
State.
My lord,
Go on.
position, my lord, is very serious to that effect, your lordship.
Yes, Srijoni Mukherjee is for the
No,
state.
last occasions. It is.
Mr. Ganguly was appearing prior to that.
Yes, so long, he got the adjournment on several occasions, my lord. Your lordship kindly appreciate. It has been started, your lordship kindly see from the date.
Fact.
So, this is, how can it be, disposed of? I don't know, the report has to be filed. These of 20, the order, first, your lordship's first order. First order. এখানে পাবি ফার্স্ট অর্ডারটা কোথাও এন্ট্রি করা আছে
A report was called for. Where is Mr. Ganguly?
since July since July
I'll just make it, I'll fix it tomorrow. Will you inform him? I'll fix it tomorrow.
let it be tomorrow. And if your lordship kindly appreciate, kindly, Mr. Devra be.
He was
No, I am not on that. Mr. Devra is the additional.
Maybe, but it has been allotted to Mr. Ganguly.
That's why, I have.
And I have always.
What happened,
I have always seen Mr. Ganguly opposing these appointments. So
I am not on that, several occasions he was informed by my junior over telephone, and she refused to accept even the telephone calls.
Let me fix a date. I'll record that even in his absence, it will be taken.
My lord.
None appears for the state respondents. No report. Is also submitted. Paragraph, let the matter appear under the same heading on 8th December.
But 8th, I will not be here. 8 to 12, my lord, I will not be here, my lord.
So 13th?
13th.
13 December 2023. Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the respondents.
But in the meantime, I will try to, my lord.
Next.
So I am for the writ petitioner in this matter, my lord. Lordship, lastly, on 27th of September, Lordship was pleased to hear both the parties, my lord. Reports have been filed and I have used my exception. Lordship, there is a interim order. Lordship was pleased to extend the interim order.
Respondent.
Respondent, my lord, honorable court's notice is there and he was present on the previous occasion.
So Trivedi was appearing.
Yes. Now, here the, my lord, petitioner's lease has been terminated by applying wrong clauses and without there being any opportunity of being heard. My lord, the only thing is this, I complained that the facilities which were provided by the, used to be provided by the railways were not sufficient. Rakes are not being placed at the proper time and there has been unilateral change of the destination station. It has been extended to some other station. And for that, willingness is required to be obtained from me, being the present lessor, as per the policy says so. That was not obtained, my lord. I complained before the Southeastern Railway, being the tender issuing authority. They have acknowledged my complaint and forwarded it to the Central Railway for redressal and grievance. And they said that it will be resolved and it will be communicated back. And what was communicated is the termination letter, which is under challenge before your lordship. And by termination has been effected without giving me an opportunity to be heard. And my lord, and there being no breach on my part.
Respondents are not appearing today. I'll fix the matter next. On the other side of the vacation, your interim order will be extended.
Last day, my lord. Any day tomorrow also.
Next, other side of the vacation, I said.
In a January, my lord.
In January,
it should be, my lord, one hearing is required to dispose it of, my lord.
But they should be present. Please inform them in the meantime if you can.
I will definitely inform. They ought to have appeared today
None
at least.
appears for the respondents. No accommodation is sought. Paragraph, let the matter appear under the same heading on 19th January 2024. Paragraph, the interim order granted earlier is extended till 31st January 2024 or until further orders, comma, whichever is early.
Grateful.
Next.
For the petition in this matter, my lord.
Here, my lord, there was a direction to file a short report. We have received the instruction just yesterday, some further development before the, my lord, state government tendering committee. So, my lord, that has to be incorporated. My lord. This is the instruction received, my lord. They have. I'm asking some 1 week's time, my lord, is ready. My affidavit is ready, but I'll have to incorporate this.
I think in that case, you need to come back after the vacation.
After the vacation.
Learned counsel for the second, you're the second respondent. Learned counsel for the second respondent seeks extension of time to submit the report in the form of affidavit as sought. Seeks further extension. There was already an extension on the earlier date.
My lord, but these are recent development I need to, my lord, bring on record.
Paragraph, let the matter appear under the same heading on 17th January
17th January
2024. Please serve an advance copy.
My lord. এটা করে ফেলি আমরা।
30. Anyone? I'll dismiss it. None appears for the petitioner. No accommodation is sought. It appears from the conduct of the petitioner. Dismiss for default. Other than steps. Other than steps. 31.
31, my lord, I am for the petition. This is my affidavit of service. The petitioner is a holder of a permanent stage carriage permit. The permit was issued in the year 2021, but thereafter the respondent authority withheld to issue timetable in favor of the petitioner, and therefore the petitioner is unable to ply her vehicle. Ultimately,
after expiry of 2 years, 2023, issued a timetable for a period of 1 month. And
For a
before
period of 1 week.
1 month only. And before expiry of the validity period, the petitioner made an application for extend the validity period of the timetable. But the respondent authority took no steps. And therefore, the petitioner's vehicle is now become also idle. Lord, kindly come to page 16. That is timetable.
Yes.
Provisionally approved for 1
1
month.
month.
That is on 7/9/2023. And thereafter made application
On 5th.
on 5th October.
Let
Before,
this be considered.
all right, or till such consideration to allow her to ply her vehicle in terms of the old,
Can you apply without, it will be
in
considered
terms of the earlier timetable,
weeks.
within 2 weeks or within a week, my lord, because it become ideal. since-
Along with any objection submitted.
What objection?
In accordance with law.
In accordance with law.
Thereafter also made representation, that is at page 18, and there is a prayer to allow to run her vehicle in terms of the timetable dated till such grant of further timetable.
How can you ply your vehicle in terms with the expired timetable?
How the authority can do in this fashion?
That's why
In
I
this
said 2
fashion.
weeks.
All right.
That's why I said 2 weeks.
10 days, 10 days, only 10 days, within 10 days.
Affidavit of service.
The act of the administration.
Petitioner is the holder of a permanent stage carriage permit in the route Tehotto Ghat to Krishnanagar. Stop. Provisional permit was issued in favor of timetable, not permit. This is timetable, isn't it?
Yes, timetable.
Provisional timetable was issued, was issued in favor of the petitioner by the authority for a period of 1 month from 7th September 2023, which has since expired. Stop. The petitioner submitted a representation before the authority on 5th October 2023 as well as 9th October 2023 seeking extension of the timetable representations which are yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Representations at the earliest. Affidavit of service bole Paragraph. Learned counsel for the respondents submits that the secretary.
Yes, ma'am. Respondent number 4.
Fourth respondent be directed to consider the representation in accordance with law upon taking into consideration objections, if any, submitted before the authority. Paragraph. In view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representations submitted by the petitioner dated duto date given, respectively, within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, and taking into consideration any objection which may have been filed before him, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which. None appears for the petitioner. Serve করছে কিনা জানি না petitioner করো আরেকটার উপর দেখলাম একই দিন এসেছে বলি এটা appears for the conduct দুটোটা করো 632. Where is he? He generally appears every day. He's a regular, yes. In absence of the petition. Tomorrow. None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the same, or day after tomorrow, because he may not be there. I don't know. Let the matter appear under the same heading on 6th December. 7th is a Thursday, 8th.
8th December.
Group 7 motions over.
Group 1 hearing matters. Item 633.
633, I appear for the KMD.
No one.
Because having group 1 matter, I'm mentally prepared to come at 3:30.
Why? I have recorded. 3:30 or after completion of
Or
Group
after
7
completion.
motions. Yes. তাই বলেছে তো?
In this matter, state is to file an affidavit. And I was told in the morning that affidavit is ready. Mr. Bandyopadhyay is appearing for the state.
Where is Mr. Bandyopadhyay?
Telling that affidavit he has made ready. Nobody.
Let all be shifted to January if no one is there. None appears for the petitioners and the state respondents. Paragraph. Affidavits are also not complete. Paragraph, let the matter appear under the same heading in the monthly list of January 2024. Monthly list of January.
Monthly list January.
Huh? 634.
My lord, I am for the petitioner, my lord. Mr. Rahul Karmakar is appearing in this matter, but he could not come to the court, my lord. I am praying for adjournment today, ma'am.
Affidavits are exchanged.
I don't know, ma'am.
File it. No, you have not used the affidavit in reply. Learned counsel for the petitioner seeks accommodation. Paragraph, affidavit in reply is yet to be submitted. Paragraph, let the matter appear under the same heading in the monthly list of January 2024.
634 minutes.
Next.
Great, ma'am.
636.
There was a direction for filing affidavits. I have affirmed my affidavit within time and sub.
State has filed.
State, I have no copy. It was not sub. May I file my affidavit?
Mr. Bandyopadhyay again in this matter. Anyone for the petitioner?
No one.
Petitioner in person as well. The petitioner is not present before this court. Paragraph, none appears for the state respondents. Paragraph, affidavit in opposition submitted on behalf of the is taken on record. Paragraph, since exchange of affidavits is not complete, comma, let the matter appear under the same heading in the monthly list of January 2024.
$637.
None appears for the parties. Let the matter appear under the same heading in the monthly list of January 2024.
$638.
Same order.
$639.
In this matter, on behalf of Mr. Amit Khan, my lord, I am praying for not to them, my lord.
Affidavits are complete.
Possibly, my lord.
Affidavits are not complete. None appears for the state respondents. The learned counsel for the petitioner seeks accommodation. Paragraph, affidavits are yet to be exchanged. Paragraph, let the matter appear under the same heading in the monthly list of January 2024.
$640.
639, your lordship, appear for the national high.
You've used your affidavit?
Yes, your lordship.
Used?
We have already filed our affidavit.
The state is yet to file.
640.
640. None appears for the parties. Let the matter appear under the same heading in the monthly list of January 2024.
$641.
Same order.
$642.
For the petitioner, I am led by Mr. Shami Mohammed. He is just this one is legs, Lordship.
You are for the petitioner?
Lordship. I'm pretty only not today, Lordship. He is engaged in court number 40.
Affidavits?
So all are complete, Lordship. It's a hearing matter.
State is the principal respondent.
Lordship. Chonji there. I shall serve notice again and
state has used affidavit. I'll fix a date in January.
Lordship,
before vacation, not possible. On prayer, none appears for the state respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th January 2024.
43.
My lord, I am led by Mr. Devasis Banerjee, behalf of the petitioner, my lord. Behalf of the petitioner, my lord, I am led by Mr. Devasis Banerjee, appearing for not today, my lord. This matter would require time. Mr. Siddiqui is also appearing for the state.
Affidavits are exchanged.
Affidavits are exchanged. So long.
None appears for the state respondents. Who is appearing for the state in this matter?
Mr. Siddiqui, TM Siddiqui.
None appears for the state respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th January 2024.
$44.
Or in this matter has been adjourned, my matter. 642 was there. My junior was there. It is fixed on 15th January. Can it be before
to his vacation. Is it possible, my lord?
Not possible. Your junior had requested for it. Not possible. Hearing matter.
No, not for that, my lord. There is some pressure on my client. In fact, my lord, the police has called me. This
Speak
is
to the police. The matter is pending before this court. Consider. None appears for the parties. Oh, let the matter appear under the same heading in the monthly list of January 2024. Didi, Patat, first order sheet. 8. Next.
645. No, I am for the Malad petition, my lord.
Respondents' affidavits are exchanged.
Everything, my lord, completed, my lord. The petitioner is, my lord, 83 years old, man. Present. And, my lord, he is, my lord, allotted a plot of land in the, my lord, new town.
I do not find anyone today. It will appear in January. Yes.
My lord, kindly fixed it, my lord.
This, I'll fix a date.
My lord, before my
None
lord
appears
vacation.
for the respondents. Paragraph, let the matter appear under the same heading. On 10th January.
My lord, kindly, my lord, before vacation.
Before vacation, not possible.
My lord, this is the, my lord, third time, my lord, respondent not happy.
Come back and take.
And, my lord, the petitioner is, my lord, 83 years old. That's why, my lord,
Please
he,
come back on the next date. I'll consider.
646.
646. Rajiv, none appears. Monthly list of January.
647.
Same order.
48.
So I appear for the National Highway, respond number 5 and 6 in this. May I be permitted to file my affidavit in opposition, Your Lordship?
Affidavit in opposition filed on behalf of respondent numbers 5 and 6.
Yes, Your Lordship.
5 and 6 is taken on record. None appears for the petitioner. Petitioners. And the state respondents. Paragraph, let the matter appear under the same heading in the monthly list of January 2024.
Obliged.
Please serve in the meantime.
Yes, Your Lordship.
49.
649, Lord, 649 and 650. Both the matter are identical matter. Mr. Ranjit Kumar Joshua is appearing for the petitioner. He came, but he left the court due to illness. Takes up the matter Wednesday and retain its position.
Yes?
Wednesday.
After vacation, no Wednesday and all that.
I appear for the KMD in this matter, in both the matters.
He left the court due to
KMC,
illness.
yes, I understand, sir. I'm not discussing your matter.
KMC and state is also there.
State is not there, KMC is not there. None appears for the state and the KMC. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15 January.
16 16.
650.
650. 649 and
Same order, same order.
both the matter, both the matter. 649 and 650.
650 also you're
Identical.
651.
651. Rajiv, none appears for the parties. January.
652.
Same order.
653.
Same order.
ভাই ও দিদি
653 12340 next one in কোথায় আছে
49
654
649 650
654, same order. Rajiv, none appears.
Six 655
Same order. None appears for the parties. Let the matter appear under the same heading in the monthly list of January 2024.
656
What is wrong? Same order.
657
Same order.
658
Same order.
659
Same order.
660
660, my lord, I'm for the petitioner, but I'm paying short password, my lord. And a brief is, my lord, not with me, my lord, that's why.
The state is also not there, respondents. Affidavits are exchanged.
Yes, yes, my lord. Let me have fixed any day, my lord, next week, my lord. I shall intimate the day, my lord.
Before vacation, no further date is possible.
And here, my lord, Union of India is the main party, my lord.
Yes, the matter is ready.
Yes,
I'll
yes.
fix a date in January.
Yes, yes, ma'am.
8th January. None appears for the respondents. Paragraph. Let the matter appear under the same heading on 8th January 2024.
Good.
661
Affidavits are exchanged.
Affidavits have been exchanged, long exchanged.
Respondents.
Date
10th January.
10th January.
None appears for the respondents. Let the matter appear under the same heading on 10th January.
I just want some, because this relates to, my lord, a serious issue. My lord, it relates to, my lord, the acquisition of leasehold interest in the tea garden land. Now, the acquisitions are made by the National Highway authorities or by the central government. Now, the state government being the original owner, my lord, now they issued a circular that while paying the compensation, the ratio will be 1:9. And 9 will go to the state government, only 1 will go to the lessee. But this is directly contrary to the, my lord, the Supreme Court's decisions, and the state government having an interest in the land. In fact, my lord, they would be also beneficiary of the acquisitions. But they cannot issue this type of circular. And in fact, this circular is being, my lord, followed by the, my lord, arbitrator in the national, while determining compensation under the National Highways Act, and the collector also. That is why, my lord, this
You've
is.
challenged the circular.
I have challenged that circular. My lord, that is the subject matter of this writ petition.
Come back on the next date, I'll deal with it. If you can, please inform the respondents in the meantime.
Because they have used their affidavit in opposition also.
662
Item number 62, I'm for the petition. I'm praying not today, my lord.
Not today takes you to 17th January.
17 January.
On prayer, none appears for the respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17 January 2024.
664
None appears for the parties. Let the matter appear under the same heading in the monthly list of January 2024.
63 mentioned.
Order হলো। আমি অর্ডারও করলাম তো 663
Mention also.
Lordship, in item number 660, I appear for the respondent corporation.
Pass, sir, I'm sorry. An order has been passed.
665.
665. None appears for the parties. Let the matter appear under the same heading or in the monthly list of January 2024.
666.
Same order.
Six 667.
My lord, item number 667, 668, I am praying for not today.
17th, I fixed the earlier matter, isn't it? In your matter?
Yes, madam.
Same date.
Okay, my lord.
None appears for the respondents. Mashu? None appears for the respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17 January 2024.
Much appreciated, my lord.
7 and 8.
668.
7 and 668.
Yes, my lord. Yes, my lord. Much appreciated.
668, same order as 667.
669.
None appears for the parties. Monthly list of January.
Six 70.
Same order.
671.
Same order.
672.
672, Mr. Rahul Kormokar is appearing in this matter. He could not come to court today due to some personal difficulties. I'm praying for an adjournment.
Fine. Affidavits are exchanged. Are you aware?
No, your lordship, I am actually not briefed on neither a junior of him. So this was
So I cannot
just.
record his name. I cannot record his name. He's not in court at all.
Okay. No.
Affidavits are not there. Bashu, none appears for the parties.
Okay.
Monthly list of January. Next. Monthly list of next.
673.
Same order.
74.
Same order.
675.
Same order.
76.
None appears for the petitioner. Monthly list of January.
677.
None appears for the parties. Monthly list of January.
78.
Lord, I am for the respondent. Lord, I am for the petitioner.
Affidavits exchange.
Affidavit exchange.
Seventy-seven.
78. 78.
What about the state?
State.
State was served.
Yes, yes. State was served. They have filed opposition. I have filed my reply and they have received it.
State was never represented.
My lord, kindly see, my lord.
Upon I would like
This
to
is,
shift it to the
my
monthly
lord,
list
this
of
is
January.
kindly have a look at this. It din na Joseph. My lord, this is filed by Mr. Bandopadhyay's junior. And this was, I was served and they have appeared, my lord, and they have used an affidavit in opposition. And I filed my reply to that. HON'BLE.
1 to 7 is KMDA, not state.
1 to 7 came.
This is the KMD.
I do not know whether state has filed affidavit or not.
5-7. I've taken up 5197.
1 to 7. In my copy, my lord, 1, 2, they are the collector. And 7 is executive engineer.
Perhaps
No,
it's a different matter.
That's the earlier matter.
Earlier matter.
No, 5, 1, 5, 7.
678.
Other matter. Correct.
এটা কত লিস্টটা দেখি না
এটা 77 বোধহয় হবে
You are in 677.
হ্যাঁ
এটা 677 Basha 677 এ কি order?
That is why I was inquiring from Mr. Pan. Because some other learned advocate.
Basha টা কেটে দিই. I have recorded none appears for the parties. 677.
kindly kindly 6 কত এটা
It is 678. This is 678.
678 has been called.
677 are related.
677 যেটা আগেরটা হলো ও মানে I was there.
I'll record that.
But
State is not there. I'll fix a date in January.
I kindly fix a date in the month of January, my lord. Kindly.
Bashu 677 order করুন. None appears for the state respondents. Paragraph, let the matter appear under the same heading on 15 January.
15. Obliged.
678, no one for the petitioner.
No one for the petition. Affidavits are complete.
None appears for the petitioner. Let the matter appear under the same heading in the monthly list of January 2024.
Yes.
700 rupee ডাকুন 700 rupee ডাকুন পুরো স্টমিক টা
78. No, 77 আমি নেই
79.
78.
Lord, I beg to appear on behalf of the petitioner. Lord, this matter is very short.
Affidavits exchange.
That has been extended, but in spite of that, my lord, your lordship can dispose of this matter.
Who is
What
appearing for
happened?
the
My
respondents?
homestead land was taken up. I
No one
applied.
is appearing for the respondents.
Joydeep Acharya. Now, my lord, the land was taken,
Affidavit is
probably not filed in the.
reply is filed, opposition is not filed.
Now, my lord, if your lordship kindly straightway come to,
I cannot without the state.
because I made an representation that this similar matter, my lord, that this honorable court, my lord, passed similar order, directing the authority to take into consideration the application and disposed of. If your lordship so direct, it can be disposed of.
In absence of the state, I cannot.
Then, my lord.
So please come back.
Yes, yes.
January.
Now, tolo, eta tolo.
8th January.
8 January.
Please inform the state if you can in the meantime.
My lord. Deeply honored.
None appears for the state respondents.
Naam likhe daw. I'm very.
Paragraph, let the matter appear under the same heading on 8th January 2020.
My lord. Deeply honored, ma'am.
Safety.
Appear for the National Highway Authority in this matter.
What is wrong today? None appears for the petitioner. Monthly list of January.
Safety 1. I am appearing on behalf of the petitioner, my lord, led by Mr. Anand Banerjee. Affidavit has been completed, my lord.
I appear for the KMD. Let a date be fixed. Let a date be fixed.
State is not appearing.
After a long
It
time.
is not a party.
It is not a party.
The state is a party.
But the KMD is the main.
Allegation is against the KMD.
The KMDA because there
It is not represented.
State
was represented.
State
KPL. Pardon?
state thank you.
Thank you.
Party state.
Mr.
The state is not.
Parthapratik Roy was for the state. So you have to, I believe you have to serve a notice. Is Mr. Roy still in the panel?
Only the party, my lord. The
State is not a party?
oh my lord. Is the Uday Bhanu Kanjilal matter?
পরে আর কিছু এগোয় না। Both of us have to take instruction from our clients.
State is not a party at all.
It's okay.
So you need a date?
Let a date be fixed because both of us, she has to take instruction also if there is any.
So by consent? By consent of the parties, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th January.
Instruction means
17th January.
82.
None appears for the parties.
82. My lord, I am for the petitioner, my lord.
Affidavits are complete?
No. There were directions for affidavits, my lord. But I am not.
Received a copy?
No.
So let the matter go out of list for the time being.
My
I'll
lord,
grant you liberty to
let it come
mention.
back in January, my lord. In the meantime, my lord, we shall update and also serve a fresh notice because I understand there was change of panel and many things in the interregnum period.
Very well.
And we shall come back.
None appears for the respondents. Affidavits are yet to be exchanged. Paragraph, let the matter appear under the same heading in the monthly list of January 2024.
And in the meantime, we shall serve notice. Much obliged.
None appears for the parties, monthly list of January.
684.
Same order.
685.
Same order.
686.
Same order.
687.
Same order.
688.
Same order.
689.
Same order.
91.
Lordship 690.
90.
Lordship 690. I am for the respondent number 5. Lordship, I am praying for not this week. My senior is very ill, Lordship.
Mr. Pan, you are appearing in this matter? None appears for the petitioner. Monthly list of January. You are giving your name, sir? You are giving your name?
Lordship.
You can give your name, not your senior's name. He is not in court at all.
691.
Are you the advocate on record in this matter? So you cannot. 691. None appears for the parties. Monthly list of January.
692.
State respondent, my lord, I am appearing.
Lordship, Mr. Kishore Mukherjee is appearing for the petitioner. I'm humbly praying to your Lordship for not today.
Affidavits are exchanged.
My lord, actually, I want to change the brief, my lord. I don't know, my lord. I have new instruction, my lord.
There was a direction.
Sushovan Sen, my lord, Sushovan Gupta, my lord, Sen Gupta was appeared.
Lordship, kindly fix the matter on a certain date in the supplementary list.
Yes, but are you aware whether affidavits are exchanged?
No, Lordship.
Let it appear in the monthly list of January.
My lord.
Grateful, Lordship.
Vashu. On prayer of the petitioner. Matter is urgent, monthly list of January.
$693.
Out of list. On your prayer. Learned counsel for the petitioner submits that he has not been able to contact his client or receive instructions in this matter till date. Paragraph in view of the same, comma, let the matter go out of list.
694.
None appears for the parties. Monthly list of January.
$695.
95, my lord, I appear on behalf of the petitioner, my lord.
Affidavits exchanged.
No, in spite of your lordship direction, state has not filed any affidavit. I believe, my lord, since there is a change in the panel,
To serve
somewhat,
afresh. That is.
my lord, I'll serve a notice, my lord.
Notice is sufficient. No, but I think when there is, just Mr. Bandopadhyay was appearing. Mr. Soumitra Bandopadhyay was appearing.
My
He's
lord.
still there in the panel. So why do you need to serve a
But,
fresh notice?
I don't know whether he's advocate on record, but whether he is in the panel, Mr. Ramchandra.
He'll take care of it. Because
Then, my
since
lord,
he-
I should serve a
Please
notice.
find out, yes. Please serve a notice. That should
Lordship,
suffice.
lordship.
Affidavits have not been exchanged as yet.
Yes, my lord.
So let it go out of list for the time being.
But after very much persuasion, the matter has been, your lordship was pleased to allow the matter to be listed.
Exchanged at all.
I think they will not. They have chosen not to.
Direction for affidavits.
There is a direction for affidavit. In fact, in last
Let it
occasion,
appear in the monthly list of January, let them come back.
let it be there, my lord. I'll serve a notice, my lord. If they fail to.
None appears for the respondents. Monthly list of January. Please serve in the meantime.
Lordship, in the meantime, I'll serve.
96.
None appears for the parties. Monthly list of January.
697.
Same order.
699.
Same order.
$700.
Same order. You are appearing. Respondents, affidavits exchanged.
But I understand the affidavit exchanged.
700 filed. Again. No use calling further. There is no one.
Yes. Only, my lord,
Let me complete this.
Oh, it is a material instructions.
well, that's
700.
701 and 702.
Yes.
Lord, just one indulgence. Item number 705, my lord, I appear for the petitioner. Can it stand over this week, my lord? Because I've been recently engaged.
It will remain where it is mentioned if you want.
Very well, my lord. I'm grateful. Will it be called today?
None of the parties are there. No use sitting here and calling matters unnecessary.
Very well, my lord.
And casting burden upon my officers.
You are always.
700. 700. Give me a minute.
My lord, my learned senior is there.
700 is 21441. Yes.
700.
I think affidavits are complete.
Yes, these are affidavits are complete in this matter, my lord.
But I do not find the respondents.
Yes.
Let me fix a date in January.
Madam.
Please inform them if you can.
Yes, I will inform them, my lord. 600, 700, 701 and 702. The similar matter.
They're analogous.
Yes. The analogous, my lord, on 15 January.
None appears for the respondents. Paragraph, let the matter appear under the same heading on 15 January 2024. Please inform them.
My lord.
Yes, Mr. Bandha.
No, 700, 701 and 702. 700, 791, and 792.
They are together.
My lord, obliged to Lordship.
Kindly seize, my lord, item number 750. I do not know why it has
Long
been.
way to go.
Yeah.
I'm not
No,
calling them.
there is a reason. My lord, this is that matter where your lordship wanted me to come back today, my lord, after the 5 minutes. Kindly seize the list once. My lord, WPA 17404 of 2018 has been tagged with a 21 matter, my lord, which is not supposed to be tagged. And it is indicated 717. My lord, this is that matter, my lord, where the respondents have, my lord, after n number of notices have chosen not to appear. This is that matter where your lordship wanted me to take a clarification as to whether the circuit bench matter is to be heard by the principal bench. This is that matter. Now, my lord, this is a 2018 matter. It has gone down. I do not know why.
Will you do one thing? Will you mention the matter tomorrow morning? I'll bring it up. It will
Tomorrow
not be
morning, my
correct
lord.
on my part to do it now, this way. Please mention.
My lord, I was only humbly beseeching, my lord, tomorrow morning I shall. My lord, my prayer will be, my lord, it will be placed in the supplementary list. This matter is hanging. Your lordship was pleased to direct it to appear today. And it has, my lord, gone down
Since
there.
I have not called the matter today, I cannot jump to
Very good.
750.
Tomorrow, my lord, I shall mention.
Lord, my learned senior.
And please mention upon notice to the other side.
My lord,
Otherwise, it's not accepted.
my lord, notices have been sent. Notices have, this is that matter where lordship desired that, my lord, a report come from the registrar.
I have a suggestion. Please wait till tomorrow. Monthly list matters are separated from supplementary list matters. I have decided not to put in supplementary list matters into monthly list. That makes the list longer so that that remains separately. So tomorrow, please check the list. And please see the item number and then come back.
Lord, as I
This is technical. Let us see what happens tomorrow.
Lord, just to mention, Lord, my learned senior is there for the respondents in item number 705,
I've
which I
got
just
till 700, sir. I'm sorry. Come back.
that will be tomorrow.
If you want to mention tomorrow morning 10:30 upon notice to the other side. I insist. Otherwise, it will not be taken up, right?
That is also not necessary because Wednesday again.
It is the monthly list.
It's in the monthly list, yes.
Also in the supplementary list. Please mention upon notice to the other side.
He prays for accommodation.
Yes.
He prays for accommodation.
No, Lord, the reason I'm praying for
Not called.
the reason for praying an accommodation is, Lord, that I've been just engaged. I'm not aware of the facts as well.
So let it remain as it is.
Very well.
Why are you making these submissions? Not necessary.
Very well.
Take your time, go through the brief, and then come back if you want to mention.
Very well. I'm grateful.
Since you're asking for an accommodation,
Yes,
let
madam.
it remain as it is.
Very well, madam. Very well.
দিদি রেখে দিন আর ডেকে কি করবো নেই তো কেউ
Newly engaged হয়েছে।
তারপর দেখি।
এই এরই শেষ করে দাও আমার পিটিশনটা।
The list collapsed today. Hearing matters difficult.